101 of 2016.
Appeal dismiss.
Item 47, RSA 32 of 2023.
Appeal allowed.
Item number 48, CRP 11 of 2024.
Petition dismiss. Appellate.
Item numbers 49 and 50, CRP 94 of 2024 and review petition 56 of 2025.
Both the petition dismiss.
51, 78 of 2025.
Dismiss.
Item 52, bail application 1918 of 2025.
Dismiss.
That will be Lordship. Lordship, I would like to mention for listing will RSN for admission hearing on day after tomorrow.
When?
Day after tomorrow, my lord.
Admission hearing.
Admission hearing.
May I please, Lordship?
Another I am, my lord, for on Friday one. For injunction.
On?
Friday, my lord. First.
May I beg to mention
18.
item 6. May adjourn for the day may fix on 21st July, next Monday.
When?
Next Monday, Lordship, 21st July.
Item number 6.
Item number 6.
And appear being made by Mr.
A. Ahmed.
A. Ahmed, learned counsel for the petitioner. The matter is then adjourned to be listed on next Monday.
On 21st.
May I please, your lordship? For withdrawal, man, tomorrow, man. For withdrawal, RSN. Withdrawal of RSN.
RSA.
RSN, withdrawal.
Is a lordship. Lordship, I beg to mention for listing on an item lordship. On Wednesday lordship.
Is there any urgency?
Matter is fixed on 24th of July lordship. In that time.
Wednesday. On 17th, Thursday.
May I please, your lordship? I beg to mention for a listing of a motion matter, lordship, CRP, on
When?
Friday, lordship.
Right.
May I please, your lordship? Similar prayer, lordship, for listing of a CRP IO, lordship, possibly on Wednesday, because before trial go, it is fixed on 18, lordship. Friday, lordship.
Wednesday.
Obliged.
Your Lordship, I beg for listing of a MSc appeal. In this, the appeal was admitted, but in the stay petition, only notices were issued, Your Lordship. But the claimants, they have filed an execution petition in the lower court. So we need to get orders on the stay petition, Your Lordship. Can it be listed on this Wednesday?
Wednesday, party was missing.
My lord, I beg to mention for listing of an LA appeal, land acquisition appeal, my lord. My lord, in this case, we had filed an
When
IA.
do you want?
My lord, we are challenging the order. Past, my lord, we were not a party in the appeal, in the land acquisition proceedings below, but then the execution has been initiated against us. My lord, on Wednesday, my lord, because the execution is coming up on 21st.
We have given many cases already. On Thursday, 17th.
My lord.
May I please, your lordship? I beg to mention for listing an RSA 35 of 2025. Matter may be listed on day after tomorrow, your lordship. An execution
In
proceeding
which
is
column?
going on.
In which column?
Yes, sir.
Motion?
No, your lordship, on order 41 hearing listing.
Wednesday, we have given many cases already. On Friday, 18th.
No, your lordship, on 17 years, execution is already on under process.
Yes, sir, Lordship, what do you do?
When? Okay. Okay.
Obliged.
Wait, pleases your lordship. First, I would like to mention this IA lordship for listing tomorrow lordship. We have an urgency because the claimants have sent a letter to their counsel saying that they will go for execution. It is a delay petition lordship, only the order for notice to you. Tomorrow. Can you oblige?
May please, your lordship, I beg to mention for listing MFA for hearing, my lord. This matter may be taken up on 31st of July, madam. Or 5th of August.
Not 31st, in the month of August,
5th of August.
7th August.
Again. Highly obliged, your lordship.
Lordship, I beg to mention one IF for order, Lordship. In fact, this matter was mentioned before vacation to be listed today, but somehow it is not listed, Lordship. This execution petition is pending, Lordship. So my prayer is, Lordship, can it be taken up tomorrow, Lordship?
Tomorrow may not be possible. Hearing date,
Hearing date on Friday.
Friday.
I did.
May I please lordship, my lord, item number 16, I'm praying for the withdrawal.
Item number 16 for?
Motion item number 16.
Yes, when?
Withdraw, I'm praying for.
Want to
withdrawal.
withdraw?
Yes, my lord.
Yes. What is your name?
Jerry Mosang.
Say?
J Mosang, I'm appearing on behalf of IS Mazumdar.
Ms. J. Mosan, Learned Counsel, appearing on behalf of Mr. I.S. Mazumdar, Learned Counsel for the petitioner. Submits that she has the instruction to withdraw this petition. There is accordingly allowed this CRP stands at disposal of on withdrawal. Okay.
Much obliged.
May I please, your lordship, we are for listing lordship, MSc appeal lordship. On hearing lordship, hearing matter lordship. On any hearing day lordship next week,
On
I-
12th August. 12th August.
next week,
July not possible. Too many cases. Hearing too many cases. Only one bench is available.
agencies lordship, the 50% not released lordship.
Pardon?
Agencies lordships are 50% not released lordship.
July too much cases. But in the first
Next-
week of August,
Dates?
7th August.
Yes.
Items for motion. Item number 1.
Yeah, please, your lordship. Lordship, transfer petition by wife. Both are residents of Silchar, lordship. Husband is a army man. He is working in the Indian Army. Right now, he is posted in Tinsukia district. So both of them are separate since 2022. Wife is residing at Silchar. He has filed a transfer petition. He has filed a divorce petition at Tinsukia, lordship. Both are residents of Silchar, however, permanent resident.
Where does it was situated?
Yeah, at Tinsukia, lordship. He is staying at Makum Army headquarters. So he has filed a case at Tinsukia court.
Wife is residing at Silsar.
Silchar, along with her 9-year-old child.
Third, Mr.
A Kakoti.
A capital Learned Counsel for the petitioner. This petition under section 34 of the 24 dated section 151 of the Code of Civil Procedure. The petitioner has applied for transferring titles of certificate matrimonial. Case number 60 of 2025 pending before the Court of Learned Additional District Judge Tinsukia to the Court of Learned Principal Judge Family Court at Kasar, Silsar. Mr. Karpati, Learned Counsel for the petitioner submits that the petitioner is the wife of the respondent hearing who had instituted, and the respondent hearing had instituted one divorce proceeding being titled certificate matrimonial case number 60 of 2025 before the Court of Learned District Judge Tinsukia, and that both the parties are belonging to Silso, and the petitioner is residing at Silso with her minor
9-year-old daughter.
daughter, with a minor daughter, and that the respondent herein is serving in army, and therefore he and posted at
Makum, Tinsukia.
that Macom, and therefore he instituted the aforementioned titles of before the Court of Learned District Judge, Additional District Judge Tinsukia. And since the petitioner is residing at Silsor, it would not be possible on our part to contest the aforementioned proceeding at Tinsukia, and therefore it is contended to allow this petition. The submission of Mr. Kakoti, Learned Counsel for the petitioner, needs further consideration. Addresses this. Notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also the usual process within a week from today. And considering the submission of Mr. Kakoti, learned counsel for the petitioner, feel returnable that further proceeding of title suit within the matrimonial December 60 of 2025 pending before the court of learned additional district judge Sensukia as state appropriates.
Deeply obliged, Lordship.
Item number 2,
May I please, your Lordship? My Lord, that's my petition, my Lord, filed by wife, my Lord. And she is staying at Tifu, my Lord. The divorce proceeding is going on at that family court Silchar, my Lord. That
The petitioner is residing at
Tifu, my Lord.
before.
Tifu, my Lord. And husband is staying at Silchar, my Lord. He filed a case at Silchar, my Lord. Family court Silchar, my Lord.
Petitioner is permanent resident of Defo
Tifu, my Lord.
and the respondent
Respondent is still Silchar, my Lord.
Silsar.
Silchar. Our main ground is, my Lord, the distance, my Lord, is 258 kilometers.
Pardon?
The distance, my Lord.
What is the distance?
258 kilometers.
200?
58 kilometers.
What means that?
C. Chakraborty, my Lord.
C.
Chakraborty, my Lord.
C. Chakraborty, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring FC written by civil case number 506 of 2024 pending before the Court of Learned Principal Judge Family Court Kasar Silsor to the Court of Learned District Judge Harvey and before. So Secretary Learned Counsel for the petitioner submits that the petitioner is the wife of the respondent hearing and presently the petitioner is residing at her
Parental home.
parental abode at Darby Anglong Defo. And the respondent herein is residing at Silsor, wherein he has instituted the proceeding. Being FC Civil case number 506 of 2024 before the Court of Learned Principal of the Family Court Kasar at Silsor. Mr. Secretary further submits that the distance between Defo, where the petitioner is residing, and the family court at Kasar Silsor is about 250 kilometer, and it is not possible on the part of the petitioner to contest the aforementioned proceeding at Silsor, and therefore it is contended to allow the petition. The submission of Mr. Secretary needs further consideration, and at this stage, notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also the usual process within a week from today. And further considering the paragraph, further considering the submission of Mr. Secretary, learned counsel for the petitioner, and the facts and circumstances on the record. Further proceeding of FC Civil case number 506 of 2024 pending before the Court of Learned Principal Judge Family Court Kasar Silsor since stood till returnable date. List of reports.
Much obliged.
item number 3,
Please, your Lordship. My senior is on his way. May it be please be adjourned for time being.
item 4,
May I please, Lordship, my lord, this petition, my lord, is filed by wife, my lord. Because her husband, my lord, filed divorce case in Borpeta, my lord. And my lord, the petitioner is residing in Bahata Sariali, and one maintenance case is also,
Husband is residing at
my lord, Borpeta, my lord, Howley, and wife, my lord, here Bahata Sariali, and one,
what is the distance?
my lord, 100 kilometer, more than 100, my lord, but my lord, one maintenance case is also pending in the, my lord, court of Rongia, my lords. Learned, my lord, court of JMFC Rongia, my lord. And another also case also, my lord, pending in Rongia, my lord. And my lord, this, my lord,
Two cases are pending between.
yes,
both
my
of
dear,
them.
Rongia, my lord.
One is 125 and the
And
other
another, my lord, 406, my lord. 406 CRPC. my lord.
IPC.
CRPC matter, sorry, IPC matter. And my lord, she has, my lord, 9-year-old daughter, my lord, she has regularly attending her school, my lord. So he has managed everything, has to manage everything, my lord.
Heard, Mr.
As a Sikdar, my lord.
S.A. Sikdar, learned counsel for the petitioner. This petition under section 34 of the Code of Civil Procedure is preferred by the petitioner for transferring TS, intermediate M, FC case number 1291 of 2024, pending to the Court of Learned Principal Judge Family Court Kolkata, to the Court of Learned Additional District Judge, District and Session Judge, Additional District Judge Ramia Kamrut. So Sikdar, learned counsel for the petitioner, commits that the petitioner is the wife of the respondent herein, and she is residing at present at Payata Sariala, and the husband and the respondent herein had instituted title, which we get MFC case number 291 of 2024 before the Court of Learned Principal Judge Family Court at Barpeta. And that two more cases, one under section 125 CRPC and the other section under section 406 IPC is pending between the parties in the court at Romania. That the petitioner has one minor daughter,
Yes, my lord, 9 years old, my lord.
9 years old daughter, and it is not possible on our part to contest the aforementioned proceeding before the learned principal Judge Family Court at Barpeta. And therefore, Mr. Sikdar has contended to allow the petition. The submission of Mr. Sikdar needs further consideration. At the cesses, notice be issued to the respondent, returnable in 4 weeks, that be taken by registered with AD and also by usual process within a week from today. And till returnable date, comma, considering the submission of Mr. Sikdar, learned counsel for the petitioner, and also the facts and circumstances projected in the petition. This further proceeding of TS and FC is number 291 of 2024, pending before the Court of Learned Principal Judge Family Court at Barpeta, stands state list after 4 weeks.
Investment, hello, blessed.
Item number 5.
Right, result also.
Yes,
Your lordship. My lord, the petitioner before your lordship is the judgment dated in a decree which was passed by the learned civil judge Bongaigaon in a compromise suit, my lord. My lord, suit was filed by the decree holder.
no,
for-
you tell me, when the execution proceeding was instituted,
Execution proceeding 5 of 2023
23.
was.
Do you aware of the judgment of Supreme Court? In civil appeal number 3640
Okay, sir.
3642 of 2025, wherein Supreme Court has directed that execution proceedings shall be concluded within a period of 6 months. Now, in your case, 2 years already elapsed.
Yes, my
Now,
lord. In-
how the learned executing court can grant you further time?
Yes, my lord, it is absolutely correct. Why I am before your lordship that I am not seeking stay of the execution. I am praying for allowing me to pay on installment. There is a bona fide on my part also because the decretal amount was for ₹7 lakhs. And on the day of passing the decree, when the matter was before the Lok Adalat, 5,000 was paid instantly. But subsequently, on 15 to 2023, the amount of ₹50,000 was paid. And an application was filed under Order 21, Rule 26.113, my lord. I opted to get myself bound by a security deposit also. My lord, as a matter of right, your lord, in that view of the matter, the learned court below has rejected my prayer. But my only
Below
prayer.
has rightly rejected your prayer.
My lord,
Where is your case?
my prayer was
Already
only for,
2 years elapsed.
my lord.
2 years already elapsed after institution of the execution proceeding.
No, I cannot, but one thing, my lord, only on the, in terms of installment, that was my limited prayer, my lord. The impugned order which is before your lordship, the learned court has said the party, the decree holder is not agreeing to accept rupees 7,000 per month. My prayer before the learned court below that I am willing to clear my amount, but I need some time. By invoking section 151 for the ends
No,
of
no, no.
this,
No.
my lord.
In view of the decision of Supreme Court, we cannot grant you time.
That is there, my lord, but as a matter of right, yes.
You
as a
see,
matter
the
of-
Supreme Court has also directed
Uh,
the High Court to initiate departmental proceeding against the presiding
No, my-
officers.
But only as per settlement, because if
No,
my
no.
salary is deducted, my lord,
Petition-
attached, and I have
Dismiss,
some
dismiss.
liabilities also, my lord.
No,
My lord,
Item number 7,
dismiss.
item 7.
May I please, my lord?
Yes.
My lord. My lord, by way of this civil revision petition, my lord, we are challenging order dated 2/5/2025, passed in Miss Civil Case number 3 of 2024, my lord. My lord, in this case, we are one of the respondents, my lord, to be precise, respondent number 1. My lord, the matter was instituted sometime in the month of August 2024. However, for the consecutive 6 to 7 dates, the petitioners were directed by the court to take steps for service of summon upon us, my lord. My lord, lastly, upon receipt of the summon, we appeared on April 2025, my lord. And my lord, annexure 5, my lord, page 33 is the impugned order, my lord. Annexure 5, page 31. Annexure 5, page 31, my lord. If I may, my lord.
Yes.
My lord, on 5/4/2025, we first entered appearance upon receipt of the summons, my lord. However, the summons were not accompanied by a plain, as is mandated under Order 5, Rule 2, my lord, CPC. Accordingly, we filed this application before the court, my lord, stating that we have not been served with the plaint along with the notice. Thus, the petitioners may be directed to serve us a copy of the plaint so as to enable us to file a suitable reply. My lord, page 33, annexure 6, my lord. May I, my lord?
Yes.
My lord. My lord, write this order, my lord. Case record put up before me as the PO has already been transferred. Petitioners are represented by the learned advocate. Respondent number 2 is represented by the learned additional GP Baksa. Respondent number 1, my lord, that would be us, is also represented by the learned advocate. Learned advocate for respondent number 1 has filed petition number 926 of 2025, stating that they had not received the copy of the plaint from the petitioners and hence prayed for fixing another date for submitting objection. Seeing the petition, heard the advocate. Considering all aspects, prayer is allowed. The petitioners are directed to furnish a copy of the plaint, my lord. My lord, this copy of the plaint was not furnished to us. And my lord, annexure 8, page 35. May I, my lord?
Yes.
My lord. Petitioners and respondent number 1 are represented by engaged counsel, Mr. So-and-so and Mr. Ed Zemomi. Respondent number 2 is absent without steps. No Hajira attendance sheet submitted for respondent number 2. And no counsel appeared before the court to represent respondent number 2 and case is taken up. Respondent number 1 and 2 have not submitted written statement and no cause has been shown for not submitting written statement. Respondent received notice before 5/4/2025. Therefore, they are debarred from submitting written statement. Petitioner is directed to submit original documents fixing 13/6/2025 for submission of original documents by the petitioner and hearing. Now, my lord, I am respondent number 1, respondent number 2 being absent. onus is not on me, my lord. My lord, we have already filed an application on the previous date when we appeared, and we stated that we have not received a copy. Hearing us, my lord, and the parties present, the court directed the petitioner to serve us a copy of the plaint. My lord, for a summon to be completed under Order 5, Rule 2, it is mandatory, my lord, that the copy of the plaint has to be annexed and attached with the summon, my lord. My lord, my prayer here is limited, my lord. I want to contest this case as I will be the affected party. My lord, I may be allowed to file my written statement once the copy of the plaint has been served upon us, my lord. And my lord, also, my lord, the court has gone ahead for
No,
a
you
hearing.
tell me whether you have received the plaint or not.
We have not received as yet, my lord.
Heard Mr. Ankara, learned counsel for the petition. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 2/5/2025, passed by the learned district judge Baksa, Masolpur, in Miss Civil Case Number 3 of 2024. It is to be noted here that by the impugn order dated so and so, the learned district judge Baksa, Masolpur has favored the petitioner, who is the respondent number 1 in the Miss Civil Case Number 3 of 2024, from submitting written statement. Written statement. Mr. Khera, learned counsel for the petitioner, submits that the petitioner has not been furnished with a copy of the plaint, for which the petitioner could not file the written statement in time, and that the petitioner is willing to contest the aforementioned proceeding, and therefore Mr. Khera submits that he may be granted one opportunity to file the written statement after furnishing, after issuing direction to the respondent.
1 and 2, my
Hearing.
lord. 1 and 2. Herein.
The respondent's hearing to furnish a copy of the plaint to him. Khera, having heard the submission of Mr. Khera, learned counsel for the petitioner, I have carefully gone to the petition, the documents placed in the record, and also there is the impugn order dated 2/5/2025, passed by the learned district judge Baksa, Masolpur, in Miss within brackets civil case number 03 of 2024. Khera, taking note of the submission on Mr. Khera, learned counsel for the petition, and also considering the facts and circumstances of the record, this court is inclined to allow this petition at dismissal itself by directing the learned district judge Masolpur, Baksa, to afford one opportunity to the petitioner to file a written statement. And further, it is provided that before giving such an opportunity to the petitioner hearing, the learned district judge shall ensure furnishing a copy of the plaint to the petitioner hearing. In terms of this civil revision petition disposed of at this motion itself, the petitioner shall appear before the learned district judge when the next date is fixed.
My lord, 8th of August.
8th of August.
8th of.
On 8th of August. Mr. Gogo, you are for
I am for Sheila.
My lord, respondent 3 state.
respondent number 2.
Lords.
Take
Yeah, I go.
also heard, Mr. Okay.
Timing item 3.
My pleasure, your lordship. In this matter, it's a transfer petition matter. Regarding transfer of a civil matter which is currently pending before the principal judge of Borpeta to the district of Bojali. Now, the backdrop of this matter is that the petitioner is the wife And currently, the petitioner has preferred this petition because of the fact that the husband has filed a title suit in respect of restoration of conjugal rights in the honorable court before the principal judge Barpeta. Now here the petitioner is currently residing at Bojali district at Pachala. And this particular husband, he also comes from the same place. But the fact is that he has filed a case from Borpeta. This is very surprising. The fact is that maybe he might have used the jurisdiction, maybe he's currently residing there. But the fact remains is that he's a permanent resident of.
You tell me, what is the distance between Pachala and Borpeta?
It is 40 kilometers, my lord.
40
Yes,
kilometers.
but the fact is that this particular petitioner wife, she is currently having a 1.5-month-old child. And the fact is that from traveling from Bojali to Borpeta, it takes 40 kilometers, coming up and down, it takes 80 kilometers. And now since she is nourishing a very small baby, and the fact that the petitioner has also filed a domestic violence case against this husband at Bojali. Now the main our contention is that why this particular case should be transferred to Bojali. The main reason is that the number one fact is that this husband, he comes from this place of Bojali at Pachala. May I peruse you to the annexure where his permanent resident is there?
Not necessary.
Yes. Now, my lord, considering the fact that on number of previous occasions, in fact, the Supreme Court has settled it that if there are grounds in respect of the petitioner wife, if there are valid grounds where it can be seen that yes, there is hindrances or there is some sort of problems in respect of the petitioner wife in traveling to the place where the husband has filed some other case against the petitioner wife. Now, in this particular, we have cited three particular case laws.
Okay.
Yes.
Okay. Heard,
At this stage, my lord, notice may be useful, my lord.
Heard Mr.
WR
W.
Mead.
Medhi, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring the title within the FC case number 158 of 2025 pending before the Court of Learned Principals as Family Court Porpeta to any competent court in the district of Bojali at Pachala, Assam. Mr. Medhi, learned counsel for the petitioner, submits that the petitioner is the wife of the respondent who had instituted the aforementioned proceeding before the court at Borpeta, before the learned principals as family court at Borpeta, though he and the petitioner both hails from same place at Pachala.
Yes, ma'am. Under the Bojali district.
Under the Bojali district, and that the petitioner is the mother of a 1.5 months old baby, and one proceeding under Domestic Violence Act.
Yes, he has
is
already.
also pending before the court of
My lord. Chief Judicial Magistrate.
before the court of
CCM.
learned Chief Judicial Magistrate Borpeta,
Bojali.
Bojali, and though the distance between Pachala and Borpeta is not too much yet, with the 1.5-year-old baby, it would not be possible on the part of the petitioner to undertake travels of 80 kilometers per on each and every day to contest the aforementioned proceeding, and therefore Mr. Medhi submits that the title suit, Certificate M FC number 158 of 2025 may be transferred from the Court of Principals as Family Court Borpeta to any competent court in the district of Bojali at Pachala. The submission of Mr. Medhi, learned counsel for the petitioner, needs further consideration. At this assess, notice to issue to the respondent, return equivalent for it, that be taken by registered post with AD and also the usual process within a week from today. And further, considering the submission of Mr. Medhi and also considering the facts and consensus. So project this petition. Further proceeding of FC. No, further proceeding of PS within the M, FC number 158 of 2025. Since state will returnable bid, list of for weeks.
Obliged, my lord. Item number 8.
With pleasure, Lordship. Lordship, this petition is preferred against order dated 3/3/25, whereby the cross-examination of the plaintiff witnesses were closed, my lord. Now, this petitioner, as plaintiff, he has filed the suit, and he has filed evidences of 6 witnesses, my lord. And after that, this plaintiff, this petitioner was cross-examined on 3 occasions, partly, because there was paucity of time. And on the 4th occasion, my lord, he could not appear before the advocate commissioner because his mother was ill and subsequently she expired. So on 31/10/23, due to his absence, the evidence of plaintiff side, it was closed, my lord. Now, when we appraise this condition, my lord, that his mother was ill due to which he could not appear, then this order dated 31/10/23, it was vacated, right? Order dated 5/8/24, my lord, which is at page number 70, my lord. So after vacation, my lord, this plaintiff, he was allowed to be cross-examined, and on 2/11/24, his cross-examination was completed. But this advocate commissioner, my lord, he inadvertently filed a false report that this petitioner did not appear before him and his cross-examination could not be completed. And on the basis of which, again, this plaintiff witness was closed, while order dated 18/11/24. Now we have filed a petition before trial court saying that this there was a false report filed by the advocate commissioner. Then it was considered, and the advocate commissioner also accepted his fault. But the case was fixed for defense witnesses, my lord, instead of further cross-examination of plaintiff witnesses, on the ground that saying that earlier only the cross-examination of plaintiff was allowed, but not the other witnesses. But my lord, here the court below has erred because while order dated 5/8/24, the entire order dated 31/10/23 was vacated, thereby restoring the case to its original state. So after cross-examination of PW1, my lord, this case should have been fixed for cross-examination of other witnesses, my lord, plaintiff witnesses, that is PW226, my lord. Instead of that, it was fixed for cross-examination of defense witnesses, thereby closing the cross-examination of further plaintiff witnesses. So that is our case, my lord. My lord, may kindly come to page number 70, my lord.
Okay, heard, Mr.
DK Medhi, my lord.
DK Medhi, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure. The petitioner has challenged the correctness or otherwise of the order dated 18/11/2024, passed by the learned Civil Judge Junior Division, Kamrup,
My lord, 3/3/25, my lord. 2 orders, my lord. 3/3/25, last impugn order.
and the order dated 3/3/2025. Mr. Medhi, learned counsel for the petitioner submits that the petitioner is the plaintiff in titles number 43 of 2021, pending before the Court of Learned Counsel. Learned Civil Judge Junior Division, Kamrup, Amindop. Then in the side proceeding, he has filed evidence on affidavit of 6 witnesses, being PW1 to PW6. And the cross-examination of the plaintiff being PW1 was completed on when it was completed
2/11/2024.
to
11/2024.
11/2024. But inadvertently, the advocate commissioner who has undertaken cross-examination of the PW1 has inadvertently submitted a wrong report upon which the learned trial court has closed the evidence of the plaintiff side and by order dated 18/11/2024 and fixed the case on 3/3/2025 for defense evidence, no, for defendant's evidence struck post. Thereafter, the petitioner has filed one petition being petition number 592 under section 151 of the Code of Civil Procedure for allowing him to cross-examine the other witnesses, his other witnesses, but the learned trial court by order dated 3/3/2025 has dismissed the same and fixed the case on 9/6/2025 for DW. The learned counsel for the petitioner also submits that on earlier occasion also, on account of failing on the part of the petitioner before the learned advocate commissioner, on account of death of his mother, the advocate commissioner has filed one report upon which the learned trial court by order dated when earlier it was closed
31/10/23.
by order dated 31
10/23.
annexure number
At page 62, my lord.
is
62.
by order dated 31/10/2023 has closed the evidence of PW. And fixed the case on 7/2/2024 for DW. And thereafter, the petitioner has filed one petition. On which date you have filed the petition?
Page 66, my lord.
On
7 February, 7/2/2024, my lord.
7/2/2024 and by order dated
5/8/24.
5/8/2024. The learned trial court has allowed the petition and allowed the petitioner for his cross-examination, but without affording any opportunity to examine the remaining 5 witnesses of the petitioner, the learned trial court by interim order dated 18/11/2024 and 18/11/2024 has closed the evidence of the petitioner and fixed the matter on 3/3/2025 for the DW.
My lord, on 3/3/25, it was closed, my lord.
No, by order dated 18/11/2024 also
Ye-
the. court
Yes, it
has-
was closed on the basis of false report of the advocate commissioner. After that, we have filed the petition. Then on 3/3/25, even after considering the advocates,
Not 18/11, 3/3/2025. 3/3/2025. And since the learned trial court has allowed the petition of the petitioner and the next stage would have been fixed for cross-examination of the remaining witnesses of the petitioner. Remaining witnesses of the petitioner. But the learned trial court has fixed the case on 9/6/2025 for reader. Taking note of the submission of learned counsel for the petitioner. And also considering the given facts and circumstances on the record. This court is inclined to allow this petition at this motion is itself by setting aside the impugned order dated 3/3/2025. Consequently, the learned trial court shall afford an opportunity to the petitioner to examine the remaining witnesses, examine his remaining witnesses, and thereafter to proceed to the next stage of the trial. In terms of above this, CRP IO stands closed.
Item nine,
valuable.
Yeah, please, Your Worship. Yeah, in this case, my lord, my evidence in examination chief is closed, my lord. The petitioner is dependent, my lord, and on the third occasion, my lord, his wife was seriously ill, my lord. That's why he could not submit the evidence in chief, my lord. That is, his petition is at, my lord, page 34, my lord, Your Lordship, my found it. And except three, page 34. Today is fixed for submission of examination in chief by the defendant. Examination in chief of the defendant is ready as per date fixed, but suddenly his wife of the defendant fell seriously ill due to her mental problem, and for which the defendant along with his wife went to the doctor, and same has been informed to engage counsel over phone. Now it is required to fix another date for submission of evidence in chief by the defendant. Therefore, it must be humbly prayed that before Your Honor allow another date for filing with the evidence in chief by the defendant and pass any order as Your Honor may deem fit. Then, my lord, order passed on 4/11/24, my lord, by closing that is at page 36, my lord. But on that day, his examination in chief is ready, my lord. But due to his wife's illness, my lord, he could not appear before the court, my lord. And I have also annexed the precisions of his wife, my lord. 4/11/24 order is at page 36, my lord. Subsequently, he also filed a miscase, my lord, but same has been also rejected, my lord, on the ground that he could not submit the medical document, my lord.
So you are the defendant in the title suit number
Title suit number 173 of 2018, my lord.
173 of 2018.
173 of 2018. Yeah, miscase order is at page 47, my lord. 10/2025, my lord, that was passed. 11 parties, page 49, your lordship may found. Page 48 and 49, my lord.
Impugned order is dated 4/11/2024.
My lord. Page 36, my lord.
Oh, you have already been granted 3 chances.
My lord,
You have already been granted 3 adjournment.
my lord, due to illness of his wife and the last occasion, my lord, and I have also enforced the petition, prescriptions of his wife, my lord. She is some gynecological problem, my lord. That's why she is mentally ill, my lord. And that is at page 53, your lordship may also found 51 and 53, my lord. I have enclosed the prescription mask, which was issued by the Caline CHC, my lord. Page 51, your lordship may found, my lord. And 59 also, my lord, on 4/11/24, my lord. The first went to on 2/11/24, my lord, at page 51, my lord. And page 53 is the
Or
on-
Mr. Ayalam, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has paid for no, the petitioner has challenged the order dated 4/11/2024 passed by the learned civil judge,
junior division.
civil judge junior division number 4 at Kasar Silsor, entitled suit number 173 of 2018. Mr. Alam, learned counsel for the petitioner, submits that the wife of the petitioner was suffering from some ailments for which he could not file the evidence. Evidence, and he filed one petition on 4/11/2024, being petition number 5 of 2006, of 06, for granting another opportunity, but the learned trial court has dismissed the said petition. And unless the petitioner is allowed an opportunity to adduce his evidence, he will suffer irreparable, no, he will suffer serious prejudice, and therefore Mr. Alam contended to allow this petition. And having heard the submission of Mr. Alam, learned counsel for the petition, I have calculated onto the petition and the documents plus on record, and also produced the interim order dated 4/11/2024. It appears that the learned trial court has refused to grant further adjournment to the petitioner on the ground that he has already availed 3 consecutive adjournment and failed to comply with the order dated 18/9/2024 by not depositing the cost of ₹1,000. Why you would not deposit the cost?
My lord, on that day, he could not appear, my lord. That's why he could not deposit, my lord. On 4/11, I have already shown, my lord. He is on medical, my lord. That's why he could not, my lord.
Mr. Alam further submits that in support of the said petition, he has enclosed two
Taxation dated 4/11.
prescriptions dated 2/11/2024 and 4/11/2024 issued by the Caline CSC. Caline CSC. But the learned trial court has not considered the same and rejected the petition number 5 of 5/06. Taking note of the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, especially considering the fact that the wife of the petitioner was suffering from some ailment for which the petitioner could not remain present on 4/11/2024 and could not deposit the cost amount. Cost amount. This court is inclined to allow this petition. The learned, the impugned order dated 4/11/2024 is then set aside and closed, and the learned trial court is directed to afford an opportunity to the petitioner to file the returns, no, to file his evidence. To file his evidence. And thereafter proceed to hear the matter in accordance with law. In terms of it, this CRP stance. Dispose of this motion is rejected.
Highly obliged.
Number 10.
May it please your lordship. Matrimonial matter, my lord. Wherein I am for the wife, my lord, wherein the husband left the matrimonial home, my lord, started living separately from 16/1/2024. Thereafter, immediately thereafter, he filed a divorce case in the family court, my lord. That is on 18/1/2024.
Yeah,
Yes.
This revision petition is against one interim order
Yes.
of granting maintenance.
Yes.
And another grievance is that the learned principal judge has not considered the decision of the Supreme Court
Yes.
in Rajesh versus Neha
Neha. Yes.
in giving effect of the order.
Order from the date of application, it should be as per Neha judgment, my lord. That can be judgment to revoke kindly.
No, not necessary.
Yes.
Uh.
And with regard to the quantum, my lord, because his income is 87,000 plus, that's been reflected in the impugned order itself. My income is rupees that I have stated 35,000 something, 37,000 something. The minor son has been studying in faculty, wherein the annual, my lord's fees and everything, my lord, monthly, it comes to 1,24,690. This has been provided in the trial court, my lord. And my lord, I have been staying in Hangrabari in a rented place, and my workplace is at Sonapur. So my expenses with regard to Hangrabari to Sonapur, that has to be, the quantum has to be reasonable, my lord. Wherein the son education, my lord, he cannot run away from his responsibility as such. My lord will kindly see his assets and liability, wherein he shows that he availed 2 bank loans, my lord. When, my lord, one is 13/2/2024 after filing of the divorce, and another bank loan he has availed it, my lord. Yes. September 2024 after filing of the divorce. This shows, my lord, that he doesn't want to take the responsibility with regard to the welfare of the minor, my lord. And these are the 2 grounds wherein the quantum, whether it is been, my lord, sufficient, reasonable for the wife, my lord, because her income is 37 plus something, my lord, wherein his income is 88 plus, my lord, 87 plus, my lord. So the reasonableness has to be looked into, my lord, because it is for the welfare of the child, my lord.
Okay, let notice go at this instance.
My lord, may I pray one thing, my lord? That will do, my lord. Only one thing, my lord. But as because the ratio, this orbiter dicta with regard to Rajneesh versus Neha made it clear to all the courts that was the question framed by the Supreme Court, wherein it stated, my lord, that whether it should be date of order or date of maintenance. And it's been made clear that it should be from the date of applications, my lord, because this is beneficial legislation, my lord. And the order itself reflects, my lord, that it is from the date of order. So, my lord, with that modification subject to issuance of notice and with regard to quantum, that will be decided later on. But this order may be modified from the date of application, my lord. At least some relief the lady gets in, my lord, with regard to 35,000, my lord.
Let us do one thing.
Yes.
we will, you file an application there
Yes.
to consider giving effect of the interim order from the
My lord.
date of filing of the claim petition.
My lord, that was submitted at the time of oral argument
no.
along with the judgment, my lord, and pointing out to the court. And even then, nothing has been reflected.
No,
That's
no,
the
no.
irony, my lord.
No. We will issue direction
Yes, yes. Then it's okay, my lord.
to consider the petition afresh,
Yes.
keeping in mind the ratio laid down by Honorable Supreme Court in the case of Rajesh versus.
Yes, that will be very helpful, my lord. Pending disposal of this quantum, my lord will decide it, my lord. Whether, my lord, this is sufficient or not, my lord. Because welfare of the minor is paramount, my lord. This court has been looking on from time and again, my lord. And that's been a, my lord, if a person, minor child is been deprived of proper education, that will be injustice, my lord. Because interim order and final order, it will take years, my lord. Evidence stage and all such comes into. And how the mother will continue the education.
Okay. Heard Mr. A.K. Bhuiya, learned counsel for the petitioner. Order dated 27/5/2025, passed by the learned principal Judge Family Court at Guwahati in May, which will make it Z, is number 43 of 2024, is challenged in this petition under section 120 or 151 of the Code of Civil Procedure, read with Article 227 of the Constitution of India. Mr. Bhuiya, learned counsel for the petitioner, submits that the petitioner has instituted one FC civil case number 34 of 2024 before the Court of Learned Principal Judge Family Court number 2, Kamrup at Guwahati. And in the said petition, in the said proceeding, the petitioner has also filed another petition for granting interim maintenance to the petitioner and her minor son.
Yes. Girl child, my lord.
No, child, minor
Child.
daughter,
Girl child.
girl child. And void impugned order dated 27/5/2025. No, upon the said interlocutory application, the learned Principal Judge Family Court has registered one Miss J case number 43 of 2024. And thereafter hearing both the parties, by the impugned order dated 27/5/2025, has directed the respondent hearing to pay maintenance at the rate of rupees
10,000, my lord.
10,000.
Yes.
So both the petitioner,
Both the petitioner, my lord,
Both the
7,000 and 3,000. At last page, 478.
7,000 to the petitioner number 1 and 3,000 to the petitioner number 2. And further, the learned Principal Judge Family Court, by the impugned order dated so and so, has directed that the said amount shall be paid from the date of the order,
Yes.
that is 27/5/2025. But Mr. Monto, referring to the affidavit disclosing the assets and liabilities of the parties, submits that the income of the respondent is rupees 87,000.
120. 87,120 of the respondent, my lord, husband.
87,120.
Yes.
And of the petitioner is
Rupees, my lord, 37,240.
37,240. But the daughter of the petitioner No, the petitioner number 2 is pursuing her studies in faculty high school,
Yes, my lord.
faculty high school, and her yearly
Expenses is 1,24,690.
1 lakh
24,690.
24,690.
And bus fare is 10,000
And
quarterly.
also, the bus fare is rupees 10,000
Quarterly.
quarter. And as such, the sum of rupees 10,000 is grossly inadequate to maintain the petitioner and her adults, the petitioner number 1 and 2. And further, there was the direction of Honorable Supreme Court in the case of Rajesh versus Neha. Reported in, what is the citation?
2021 2 SCC, my lord. 324.
2 SCC, page number
324, my lord.
324.
Yes.
Wherein Honorable Supreme Court has directed that the maintenance shall be given effect to from the date of filing of the claim petition.
Yes.
But despite of the submission made by the petitioner at the time of hearing of the petition, the learned trial court has failed to consider the same. And as such, the impugned order dated 27/5/2025 suffers from manifest illegality, and therefore Mr. Oya has contented to set it aside. The submission of Mr. Oya, learned counsel for the petitioner, needs further consideration. At this stage, let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Further, it is provided that the petitioner shall file an application before the learned principal judge family court for giving effect of the order, impugned order dated 27/5/2025 from the date of filing of the petition, that is
That is 22/4/2024.
2/4/2024. 2024. And on such petition being filed, the learned principal judge shall consider the same in the light of the decision of Honorable Supreme Court in the case of Rajesh versus Neha, especially in paragraph number
131, my lord.
paragraph number 131. 131. And the aforementioned exercise has to be done within a period of
19, it has been fixed, my lord. This 19.
within a period of 2 weeks from
2 weeks?
today.
No issues. my lord.
List after 4 weeks.
Deeply observed.
Item number 11.
Badly resolution. For the petitioner before your lordship file one title suit before the trial court, my lord. And subsequently, because of some development, my lord, he prayed for amendment of the pleas. And this amendment was allowed, my lord. Accordingly, my lord, he submitted as per the amendment order, he submitted the amended plain, my lord. Lordship, kindly have a look page 51, my lord. 51 last part, my lord, whereby amendment was allowed. My lord. Paragraph 26, page 51. In the backdrop of the above discussion and the facts and circumstances of the instant case, it is evident that if the amendment sought by the plaintiff petitioner is not allowed, the real controversy of the suit cannot be decided. Moreover, I am of the considered opinion that the prosecution amendment would not change the nature and character of the suit, and the same was filed by the plaintiff without any malafide intention. Hence, the petition of the petitioner is allowed. The plaintiff is directed to furnish the amended copy of the plaint with the documents within 15 days from today. This case is,
No, the learned trial court has allowed your petition.
yes, my lord. Now, my lordship, kindly will look here, my lord, it is provided 52, my lord, plaintiff is directed to furnish the amended plaint with the documents within 15.
No, you come to the impugn order.
Yes, my lord. Impugn order, my lord. Now, my lord, I have submitted my document, my lord, by the application page 77, NHR 5, my lord. It was, my lord, neither rejected nor allowed, my lord, which is not permissible, my lord. Impugn order page 85, my lord.
Yes, you come to the
85.
impugn order, yes.
Yes, 85. Both the parties are represented. The learned counsel for the defendant has submitted that the same, but some of the documents submitted as exhibits by the plaintiff have already been submitted before the court, and some of them have been submitted without obtaining the leave of this court, for which they sought not to be admitted. This court, in the interest of speedy trial, deems it fit to mark those documents as exhibit under objection, and the final admissibility of those documents in evidence shall be decided at the time of final disposal of the suit. The plaintiff has submitted evidence on affidavit of PW1 along with service copy of the defendant. Hence, I appoint learned so and so to record the cross examination.
So where the learned trial court has rejected your petition?
Therefore, my lord, neither my lord rejected nor allowed, my lord. It is only kept, my lord, pending at the time of disposal, my lord. At the time of disposal, my lord, there is no scope and provision, my lord, to allow the evidence to be proved, my lord.
So it is mentioned here that this court, in the interest of speedy trial, they it fit to mark those documents as exhibit under objection. And the final admissibility of those documents in evidence shall be decided at the time of final disposal.
Fine. So, my lord, petitioner, my lord, if petitioner is not allowed to prove this document, my lord, all those documents are, my lord, meaningless, my lord. And it is, my lord, otherwise it is kept as exhibits, but not allowed to be proved, my lord. Indirectly, my lord, rejected.
No, the trial court has allowed to mark those documents
Yes,
as exhibit
yes,
under objection,
and objection.
and will determine the final admissibility at the time of final disposal of the suit.
Disposal. But at the time of if my lord, the
So
evidence,
finding you have been allowed to admit, allowed to exhibit those documents.
yes, my lord. Document exhibit allowed, but it is not, my lord, allowed to be proved, my lord. If it is not proved, my lord, and evidence chapter is closed, my lord, at the time of evidence, my lord, disposal, my lord, that cannot be taken into consideration as per law, my lord.
No, where it is stated that you are not allowed to prove those documents.
Under, my lord, this court, in the interest of speedy trial, deem it fit to mark those documents as exhibit under objection, and the final admissibility. These are not admitted documents, my lord. Admissibility
No,
of
you are allowed to mark those documents.
yes, my lord. if marking, my lord, document, my lord, kept on record, my lord, and it is admissibility is not yet, my lord, accepted, then, my lord, I will not be, my lord, allowed to be proved, my lord. Admissibility is also not, my lord, accepted. At the time, at the stage of, my lord, final disposal, it will be decided.
No, you are allowed to mark those documents.
Yes, sir.
But does it mean that you are not allowed to prove the contents of the same?
Yes, sir.
Where it is mentioned?
Admissibility, my lord, and the final admissibility of those documents in the
You are
evidence.
allowed to mark this under objection.
Yes, my lord. Order is.
Where is your case?
It is, my lord, defamation case, my lord.
No. You tell me where is your case now?
My lord, we may be allowed to, my lord, exhibit, my lord, proof or exhibited documents, my lord.
Already allowed.
It is, my lord,
You
not.
go through the impugn order.
It is not, my lord, being allowed, my lord, to prove, my lord.
Allowed to mark those documents as exhibit
Yes, my lord.
under objection. Your petition is allowed.
But, my lord, petitioner is, my lord, according to my petitioner, my lord, he is not allowed to, my lord, prove this document, my lord.
Pardon?
Prove this document, my lord, he is not allowed, my lord, just only kept in record. my lord.
No. You are allowed to mark those documents. Clearly mentioned here.
Lordship may clarify, my lord, that he may be allowed to legally prove this document, my lord.
Pardon?
As per, my lord, the
No,
law, my
order
lord,
is clear. Order appears to be clear. You have been allowed to prove the documents. You go through the impugn order again. We will list the matter on Wednesday. Heard Mr. A.M. Bormuya, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 29/4/2025, passed by the learned civil judge, Senior Division, Kamrup, Aminggaon, entitled suit number 25 of 2007. List the matter on Wednesday for further consideration.
oblige.
Item 12,
May I please, this petition is referred for setting aside the impound order dated 23/4/2025, passed by the Learned Court of Civil Judge Junior Division, number 1, Nalbari, entitled suit number 106/2014. Lordship, the case was filed for declaration of right, title, interest, and confirmation of possession. The suit land is, I am the plaintiff petitioner. It is purchased land, which was purchased in the year of 1993, not ancestral property. Lordship, on 10/12/2024, we had submitted a petition for calling the volume of the registered sale deed from the office of the sub-registrar Mukalmua. We have exhibited the certified copy of sale deed.
No,
As
that's all right, but why at the belated stage, while the case was fixed for argument?
Yes, Lordship, case is fixed for argument.
Why you could not file such an application at the time of examination of the witnesses?
Lordship, it was inadvertent mistake.
No, you were,
Lordship,
can we allow to fill up the lacuna now?
not lacuna, Lordship, only document is exhibited. That the same document is exhibited as exhibit number 3. Now this is not lacuna. The real story will come out if the volume of the sub-register is produced. Already document is exhibited, Lordship. Kindly go through the order in page number 18.
So you could have mentioned it in your plaint that the original sale date number 243 of 1993 was not available with you.
Lordship, it is not
No.
mentioned. It is not mentioned.
Then-
Not mentioned. This is the mistake, inadvertent mistake.
No, can this is we can allow your care.
Lordship, as per the provision of order 16, rule 1, sub rule 3, the court may, for the reason to be recorded, permit a party to call, whether a summoning through court or otherwise, any witness other than those whose names appear in the list referred to in sub
No,
rule
that
1.
provision is there.
Yes,
And
Lordship.
that provision was considered by the learned
Yes.
trial court.
Yes. Sub-register was not a listed witness, but under this provision, although he was a not listed witness, may be called if sufficient reason is there. It is clear. Lordship, this is not like already this document is exhibited as exhibit number 3. Document is available already available in the case record. See. No new facts will come from this document. Only to ascertain whether this document is same document or some manipulation is there. The real story will come out.
No, that's all right, but after closing of the evidence,
Yes, Lordship, it is late. I agree.
after closing of the evidence, whether such an application can be allowed.
But sufficient discretion in this regard.
Discussion is there, but court cannot cause prejudice to the other side also.
Lordship, it will not delay sometimes, but not the merit of the case. Or other party may not prejudice because that sale deed is available in the record. But some wastage of time,
No.
I agree, but not merit of the case.
Where is the plaint?
Lordship, I have not annexed the plan, but petition and written objection is annexed. The petition under order 16 rule.
You file the plaint, we will see. Heard, Mr.
Ardaka.
Ardeka, learned counsel for the petitioner. List the matter on Friday, so as to enable Mr. Deka to furnish, to file a copy of the plaint of the title suit number 106 of 2014 by way of an additional affidavit. List recording Friday.
On 18th. Sergeant number 13.
Okay.
This matter election lordship that 166 lordship 166 3 petition 3 provision lordship delay of 6 months lordship. In this case lordship, accident took place 9 years back and case was filed after 9 years, and that and from the date of lordship that new amendment after 9 months. Similar cases lordship had dismissed lordship of this petitioner, but lordship I have instruction that the petition under 166 3 lordship is pending in the Supreme Court lordship, SLP. So from that point of view, lordship may consider this SLP number is dear lordship. I have that much instruction lordship. Accident took place prior to the amendment of the act lordship. 1422, it is much prior to that. After 9 years, it was filed lordship.
This order is from which court?
That is also not specifically mentioned, Lordship. I have got dismissal instructions,
Where do you got it?
Lordship,
From where you got it?
from my client, Lordship, from their office, Lordship.
Can this kind of document be considered?
Well, Lordship, up to Lordship to decide, Lordship, but I have this copy only. SLP number is dear, Lordship.
Where?
SLP number is, Lordship, in
You produce that
paragraph,
order, we will see.
Lordship.
You produce that order in SLP?
SLP, Lordship, it is pending. That will have to be.
That admission order?
That is also not with me, Lordship. I will seek instruction from my client, Lordship.
List the matter on Friday for further consideration.
Wait, please, your lordship, if this matter come after 1 week, your lordship,
After,
1 week, your lordship.
Miss, your good name?
M. Medhi, lordship. M. Medhi.
M. Medhi, learned counsel. For the petition or price for listing the matter after 1 week. Fair lot.
Bless you, lordship.
Item 15.
Let please, your worship. Let this petition against an order rejecting my amendment prayer. No, my lord, I am drawing your lordship's attention to the plaint, my lord. At page 15, my lord. Page 15, the suit is for declaration and confirmation of right, title and interest and recovery of cash possession of the shoot land and for permanent injunction, etc. Now your lordship would be pleased to turn to written statement, my lord. At page 26. Here, my lord, para 4. It is specifically stated that the suit is barred by adverse possession. So, my lord, in the initial written statement, the plea of adverse possession is taken. Now, your lordship will turn to page 27.
No, Mr. Sheikh,
My lord,
when did you file the petition? Before the trial court?
amendment petition, my lord.
Yes,
That is in 24.
24.
Yes, ma'am.
And when the suit was filed?
No, lord. Suit was filed, suit is of my lord, 43, 22.
22.
My lord, your
And-
lordship will consider
No.
that written is.
Mr. Sheikh, I am asking something to you. You
My lord.
please answer it.
My lord,
And when you have filed the petition, at what stage the case was pending?
my lord, at that stage, my lord, that evidence in chief,
Evidence
the
in chief.
PW,
And
was
whether
filed
at
in
that
January
stage-
2024.
No, you tell me whether at that stage the amendment petition can be allowed.
So, my lord, if your lordship, we read this provision, my lord.
Hmm.
Order 6, Rule 17, my lord. The court may, at any stage of the proceedings, allow either party alter or amend his pleading in such manner and on such terms. Now, my lord, there is a proviso. Provided that no application for amendment shall be allowed after the trial has commenced.
Yes.
Yes. Unless
So
the
in
court
your
comes.
case, a trial has already commenced.
My lord, that's all right. It is not stopped there, my lord. Commenced, unless the court comes to the conclusion that in spite of due diligence, the word due diligence is there, the party could
And
not
you
have
show
raised
me,
the matter. My lord.
From
Now,
your
now your
petition-
lordship would be pleased to see,
No, no,
actually,
from your petition, you show me that there was due diligence on your part.
my lord, my due diligence is the, my lord, inadvertent mistake. Inadvertently, I could not bring this, my lord, on record. So, my lord, that is the point, my lord. Your lordship will consider as many as I paid for as many as 11 amendments, my lord. 11. And learned court below, my lord, pass the order, your lordship would be pleased to see. Para 29, that page 68 and 29, para 29, 68, para 29. That, but the instant case, they stated already, by amending the written statement, defendants cannot be allowed to wriggle out an admission already made. That is all right, my lord. If your lordship finds that, yes, there was some admission, that admission, now I am denying. Then that part may not be allowed. That part may not be allowed. But what about my other amendments, my lord? What about
That,
other,
right, that proviso to section, or no, proviso to rule,
my lord?
due diligence.
Due diligence is there, my lord. Your lordship would be pleased to consider, not that the suit was filed in 2022, but what is the position? Examination in chief on affidavit filed in 2024 only. So, my lord, if we take that in 22 case was filed, it was progressing, but lastly, my lord, only examination in chief submitted in 2024 only. And your lordship will consider my first amendment, what I want to amend, that on Khorgeshwar Kolita was the Pattata. And 2, 3, 4, 5 are the daughter and son of Khorgeshwar Kolita. And how they can be made party when Pattata is living? That is one of my amendment, madam. Another amendment I want to place before your lordship. They want to say that Schedule A land is the shoot land. But in the prayer, your lordship would be pleased to see, only they claim on relief on the schedule land. So, my lord, your lordship would be pleased.
Mr. Sheikh,
Madam,
you show me due diligence on your part.
my lord, due diligence, my lord, in that case, my lord, my humble submission before your lordship, I stated in the petition that due to inadvertent, I could not file the, that written statement could not be properly filed. That is my statement before your lordship. Due diligence is that. Inadvertently, I could not. So, my lord, what happened, my lord? Advocate, my lord, advocate conducted the case. Your lordship.
Mr. Sheikh,
Yeah.
inadvertence and due diligence are not the same thing.
But if your lordship, learned court below, in what single word, my lord, said that there is lack on my part regarding due diligence, my lord. Will it be proper? I have said
no,
inadvertently, and the learned court below said there is lack of due diligence. What is the meaning of due diligence? Is there any elaboration on the part of the court? And another point your lordship would consider, 11 amendments I have prayed for. Supposing what I have admitted, that cannot be amended. That's all right, that is the law. But what about my other 10 amendments, my lord? That is to be considered. And where is the answer?
No.
Learned trial court, mere saying that there is lack of due diligence on my part, cannot deprive me, my lord.
Why?
As a whole, because, my lord, what is the answer? I have prayed for 11 amendments. Court is to see.
That's all right, but where is due diligence
Except
on your
it is
part?
a non-speaking order, my lord. My humble submission before your lordship, it is non-speaking order. Non-speaking order. Nothing has been said on my amendment prayed for. Only only the word due diligence, lack of due diligence.
That is the,
not
that
be
is the
sufficient.
law,
No,
that is
it
the
not-
law.
My humble submission before your lordship, it is not the proper order. Because the
Uh,
court by giving the
if-
word due diligence.
Mr.
My-
Sheikh, if that is your submission, then we are sorry.
My lord. Because my lord, advocate conducting the case, your lordship will consider
No, no.
that order 17,
No.
my lord,
That-
rule
that-
17, order 6, my lord,
Mr. Sheikh, that cannot be considered.
my lord. But my humble submission before you is a non-speaking order, my lord.
No, it is an speaking order.
My lord,
It is an speaking order.
my lord,
This order is an speaking order.
my lord, how my lord, other amendment, what will happen, my lord? Regarding my
No,
other
that
amendment,
due diligence,
my lord.
due diligence.
My lord, my humble submission before your lordship, my word is
Your
inadvertent.
explanation
Your
that due-
lordship, your
inadvertence
your
of
lordship will
lawyer.
consider. My word is inadvertence.
No, that will not explain due diligence.
Na- my
You
lord,
better-
I'm
Mr.
coming, my lord.
Mr. Sheikh,
My word is inadvertence. And court's reply is this, due diligence is lacking. But by these two words,
You-
my lord, by
Mr.
one
Sheikh-
words, my inadvertence
Sheikh-
is answered, my lord.
you file an additional affidavit showing your due diligence here. We will see that.
Oblige, your lordship.
Heard Mr. M.S.A., learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 7/4/2025, passed by the learned civil judge junior division Moriyao in Miche, case number 154 of 2024, arising out of title suit number 43 of 2022. Having heard the submission of Mr. Sheikh, learned counsel for the petitioner, it is provided that Mr. Sheikh shall file an affidavit explaining that there was due diligence on his part in filing the amendment petition before the learned trial court, list after 1 week.
My lord, a date, may I pray for a date, my lord? Proceeding is going on.
On 25th July.
Must oblige.
This is 17.
Yeah, please. My lord, in this case, the petition file a suit for my lord seeking relief that he may not be evicted forcibly, my lord. Petition is a tenant, my lord, against the landlady. My lord, landlady file an interim injunction was granted, my lord. In spite of that, my lord, she put up a iron gate, my lord, and started, my lord, regulating the entry of the vehicle of the petition, my lord. Then she filed a counterclaim, my lord, in the suit for ejectment, my lord. The petitioner has taken time, my lord, that the landlady filed counterclaim, my lord, in WS against the suit of the plaintiff, my lord. But she did not file, my lord, the objection against the violation petition, my lord. She violated the order of injunction, my lord. So, my lord, she has taken a ground that she wanted to start a business of restaurant, my lord, in the suit premises, my lord. But, my lord, she has installed a gate, my lord, which is contrary to her, my lord, the stand for counterclaim, my lord. So, the petitioner filed a petition that the time may be allowed till filing of the objection by the petitioner because by the defendant, my lord, because my lord, the objection of the defendant have a bearing on the ground taken the counter WS against counterclaim, my lord. That was, my lord, rejected on the next date, my lord. On the date of rejection, my lord, the respondent filed the objection, my lord. On the very next date, my lord, the petition filed the written statement.
This present petitioner is the plaintiff in the
my lord, title suit 202 of 25.
title suit number 202 of
24.
24.
My lord.
And there
was a counterclaim by the
defendants file written statement and also file counterclaim.
My lord.
And you could not file
my
your written
WS
statement against the counterclaim.
My lord.
So how many adjournments you have availed?
My lord, on 6/2, my petition was rejected, my lord. my lord, my petition was rejected on the ground, my lord, that I have not made a prayer for extension of time for filing WS, my lord. My lord, on that date, my lord, that suit, case was filed, my lord, WS against counterclaim and hearing in the miscellaneous cases, my lord. So, my lord, I have no reason to file otherwise, my lord, petition. Specific prayer was not there, my lord, that time may be allowed to for filing WS, my lord. But I have given a reason, my lord, that petition there. My lord. I have given a reason, my lord, that I could not prepare the WS against counterclaim, my lord, because of the because the defendant has not filed the written objection against my violation petition, my lord. So that petition was rejected, my lord, on the ground that the honorable court learned court below cannot direct the party to file written objection against my petition. He may file or he may not file. That is true, my lord. But on that day, they filed that objection, my lord. On the very next date, my lord, it was 6/2, it was fixed for objection and WS. My WS, prayer for WS are rejected and it was fixed for ADR, my lord. Next date was fixed on 21/3, my lord. On 21/3, I filed the WS, my lord. I filed a WS with a petition, my lord, that my WS may be taken on record, my lord. And I have also given a reason why I could not file it on 6/2, my lord. So that petition was rejected, my lord. That order is, my lord, page 60, my lord, relevant.
Okay, heard Mr. Jesse Gore, learned counsel for the petitioner. Correctness or otherwise with the order dated
21/3.
6/2/2025, passed by the learned civil judge junior division number 4, Kamrup M, Guwahati, entitled suit number 202 of 2024. Is silence in this petition under Article 227 of the Constitution of India, it is Section 115 of the Code of Civil Procedure. Mr. Gore, learned counsel for the petitioner, submits that the petitioner has instituted one title suit, being title suit number 202 of 2024. And in the said petition, in the said title suit, the respondent hearing, being the defendant, file a written statement and also file counterclaim. So Gore further says that the petitioner hearing also file one injunction petition wherein the learned trial court. Where is that order? Injunction
My
order?
lord, injunction order I have not annexed, but status quo order was passed, my lord, in
the said injunction petition, the learned trial court has granted status quo, directed the parties to maintain status quo. But the respondent hearing had violated that status quo order for which the petitioner has filed one petition for violation of the injunction order, and the said petition was pending before the learned trial court, for which the petitioner would not file her written statement against the counterclaim filed by the respondent hearing. And when the petitioner has filed his written statement on when
21/3, my lord.
21/3,
25.
21/3, 2025, the learned trial court by order dated
Same order, 21/3. Page 55.
by order dated 21/3/2025 has dismissed the same. Mr. Gore further submits that the petitioner could not file a written statement as the case was fixed for hearing on the violation petition.
My lord.
Violation petition. And unless the petitioner is allowed to file the written statement. No, unless the written statement filed by the petitioner is not accepted, the petitioner will suffer irreparable loss, no, suffer serious prejudice, and therefore Mr. Gore has contended to allow this petition. Having heard the submission of Mr. Gore, learned counsel, to the petitioner, I have carefully gone to the petition and the documents, lesson record, and also perused the ensuing order dated 21/3/2025. 2/6/2025 and 21/3/2025.
My lord, 21/3 is, if this order is, my lord, set aside, then my WS is.
Then why you have challenged the other order, 6/2/2025?
My lord, because my lord, on the basis of that order, this order was passed.
21/3/2025. In view of the submission so advanced by Mr. Gore, learned counsel for the petitioner, and also considering the facts and circumstances of the record, it is provided that the learned trial court shall accept the written statement filed by the petitioner and thereafter proceed to hear the matter in accordance with law. In terms of this CRPIO stands dispose of at this person is accepted.
Item number 18.
Next, please, Lordship. This is a revision petition of preferred under against the judgment of into an order dated 2/6/2025, Lordship. Passed by the member of the Motor Accident Claim Tribunal, Tinsukia, whereby the petitioner delay petition was rejected. Lordship, what happened in this case?
Now, where is the provision? In the new act for condemnation of the delay?
Lordship, we have found there is a provision is 166(3) within the 6 months. This claim petition should be filed. But we
And
have
beyond that?
we
Is
have
there
filed.
any provision for condemnation?
Let's say it's applicable, let's say. Section 5 is applicable, let's say.
Section 5.
Because in this case, there is a provision 159 where it is mandatory that police authorities should be submitted their report within 3 months. The honorable tribunal not consider that aspect also.
No,
In their
if that
observation
is
is
your case,
admitted.
are you sure that the police has filed the accident information report?
Yes, there we have a annex form 54, let's say.
When?
Let's say page form 54 page, let's say 27, let's say.
27. When it was filed? Where is the date?
Either GDNT case number was there, let's say 171/2022.
No, I am asking you on which date this accident information report was filed by police.
Yes. No, this report was not forwarded to the Line Tribunal, let's say. This is not
That's all right,
complied by.
but where is the date?
Who is that, let's say?
On which date this report was filed?
Here is not mentioned, let's say, actual date is.
Then
But this is
Case was registered and the case number was here, Lordship.
That's all right, but you tell me on which date this report was prepared by the
Prepared by prepared by the
Police.
IO, Lordship. It's Dumduma PS, Lordship.
on which date it was prepared?
Date is not mentioned, Lordship.
Then we have to assume that it was filed within the period of 6 months.
Within that 6 months, but it was not forwarded to the, because there is an observation, Lordship, made Perus,
No,
Lordship.
one endorsement is there forwarded, FDD. There is also signature.
Yes, Lordship. But in impugn order, Lordship, there is an observation, Lordship, in page 36, Lordship. Page 36. May I read, Lordship? This view is also supported by the fact that by the way of subsection 4 of the section 166, the legislation had provided that the claims tribunal shall treat any report of accident forwarded to it under section 159 of MB Act as an application for compensation under this act. However, it can be inferred that it was not the intention of the legislature to deny any person the benefit of the act. The said section 159 of amended MB Act requires a police officer to submit accident information report to the claims tribunal within a period of 3 months from the date of the accident, even though the record reflects that an FIR had been filed in respect of the said accident and a certified copy of Form 54 is attached to the record. It is unknown as to why the provision of section 159 of MB Act was not implemented by the police by sending a copy of the accident information report to this tribunal in time, for which the claim for compensation could not be taken by the tribunal. Now it is to be seen as to whether for the said lapse on the part of the police officer, the claimant can be denied her rightful compensation or in the list to present her application for getting an adjudication. The answer has to be in the negative, but the concern of the court is with regard to the contents of the application for condoning the delay. Having answered the said question, this court now takes up the most vital issue, that is, whether the application for condonation of delay contains sufficient cause for its condonation. The averments of the claimant for condoning the delay is ignorance of her right to get compensation, so it has to be decided as to whether ignorance of the right can be considered to be a sufficient cause. Further, the application also does not reflect for whom the applicant had the information about her right to get compensation on account of the early death of her husband due to an accident involving a motor vehicle. And page 37, last portion, Lordship. While this tribunal is not unmindful of the principle laid down by the Honorable Supreme Court in so-and-so, which provides the courts ought to be liberal while accessing power of condoning delay, but at the same time acceptable and sufficient reasons for condoning the delay should also be stated in the petition, and the applicant ought not leave it to the court to fish out the sufficient ground which will find satisfactory. No such grounds being present in the instant application under consideration, for which this tribunal is constrained to reject the application for the condonation of delay, and consequently the said application shall stand dismissed. There shall be no order as caused.
No, Mr. Bora,
Yes, Lordship.
you obtain a instruction on which that Dumduma PS case number 171 of 2022 was registered.
Yes, Lordship.
And further, when this Form 54 was prepared by the investigating officer.
Allow me to file additional affidavit.
Yes.
In this regard.
Or Mr. Bora, learned counsel for the petition. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order. Dated 2/6/2025, passed by the learned member motor accident claim tribunal Bitsukia, whereby the learned tribunal has dismissed the application number 304 of 2025 dated 4/4/2025 filed by the petitioner for condonation of delay of 1053 days in preferring claim petition. Preferring claim petition. Peruse the impugned order dated so and so. And also, now peruse the petition and the documents plus on the record, and also peruse the impugned order dated so and so. List the matter. After 1 week, then
The 2 weeks.
after 2 weeks, for further consideration. And in the meantime, Mr. Bora, learned counsel for the petitioner, shall file an additional affidavit as to the date on which Dumduma PS case number 171 of 2022 under section 279 338 IPC has been registered, and on which date the form 54 at page number 27 of the petition was prepared by the IU, and whether the same was forwarded to the tribunal or not. List according.
Item number 15.
My lord, in this case, what has happened actually, my lord, one title suit is pending, my lord. We filed one title suit because we purchased a plot of land, my lord, 10 bighas, more than 10 bighas of land. That suit is pending. After the, my lord, purchase in the year 2006, my lord, 2007 mutation process was there. But subsequently, from whom we purchased the land, my lord, after her death, my lord, her legal heirs, my lord, incorporated their names, my lord. And subsequently in the year 22, my lord, that land has been sold to respondents, my lord. Now, my lord, already process going on, my lord, matter is pending there, but 2 notice served upon the respondents, my lord. My lord, saying, my lord, for LA case, my lord. Otherwise, my lord, a injunction petition was, my lord, also filed, but in both the court, my lord, we have lost, my lord. Saying that, my lord, all the ingredients are not in our favor, even after purchasing the said land. First, your lordship, kindly peruse your lordship. The first reject order in midday case 157.
Let notice go at this system.
Yes, my lord, notice me.
Our Mr. Das, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. Read it. Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 30th/5/2025, passed in Miss Appeal number 6 of 2024, passed by the learned civil judge senior division Buluri. In Miss J case number 157 of 2023, passed by the learned civil judge junior division Bilasipara. Peruse the petition in the documents plus and record, and also peruse the impugned order dated 30th/5/2025 in Miss Appeal number 06 of 2024, and also the impugned order passed by the learned civil judge junior division Balasipara in Mize case number 157 of 2023. Let notice be issued to the respondents, returnable in 4 weeks, for which step be taken by registered post with AD and also by usual process within a week of today. Madam, you are appearing here.
Yes, sir. I'm appearing.
One
One
and two.
One I'm appearing. 2 to 5 I'm appearing.
You are for
Revenue Department. Respondent number 1.
respondent number 1. Mr.
Yes, doctor.
And
Yes, doctor.
yes, doctor. Learned standing counsel for the respondent number 1. Then Madam Bormon for respondent number 2 to 5. 2 to 5. However, no formal notices referred to be issued to the respondent number 1, 2, 3, 4, and 5 since they are represented by their and this on by the government advocate. Step upon rest of the respondent be taken by registered post with AD and also by usual process within a week from today. Let's start for weeks.
20.
May please, Lord. Well, I am the plaintiff. The suit was for partition and separate possession. The suit was decreed. Then, my lord, the defendant filed title appeal that was dismissed. Again, they filed RSA in this honorable court, my lord, which was also dismissed. My lord, the execution proceeding was started, my lord. Then then precept was granted, my lordship kindly see my lord. Page 105 is the order of precept passed in the title execution case. My operative part is at page 106. 106, ma'am. As the suit was decreed in favor of the plaintiff and preliminary decree has been drawn, let the precept issued to the deputy commissioner the partition suit land and hand over possession to the plaintiff over their share. Plaintiff is directed to take steps. Then, my lord, kindly see the report of the circle officer. This is the report. My report, the land has been partitioned and the plaintiff's name has been incorporated in the related job only. Thereafter, my lord, this opposite party number 1 filed an application, my lord, Annexure 8 on 11/4/2025 that he is owner of a part of land which was decreed, my lord, 3 kata 10 lectures. The learned trial court below, and we filed our objection, my lord. The learned trial court below, my lord, passed the impugn order. The lordship kindly see. My lord, page 120. Annexure 10, page 120. Third party petitioner and opposite party both are represented. Opposite party decree holder has submitted written objection with a copy, furnished copy to the other side, heard both sides, peruse the materials on record. It appears that the third party petitioner has sufficient interest in the suit land as they are possessing and residing over the suit land on the strength of sale deeds. Any execution proceeding over the suit land will directly prejudice the interest of the third party. Considering the material submitted by the third party petitioner, it appears that they are liable to be made parties to this execution suit. The documents submitted by the third party petitioner are subjected to probe, and as such the same is a matter of trial, and therefore if the third party petitioner is not made party to the execution suit, then it will certainly prejudice them. Hence petition number Imani is allowed, and accordingly Mr. case number stands allowed and disposed of. DA is directed to insert the name of the third party petitioner as defendant in the with reading in the title suit number 46 of 2002 on or before the next date fixed. Then on the next page, your lordship see the order passed in that suit. The instant suit is revived on the strength of order passed in Miss J case number 98 of 2025 dated today. DA is directed to insert the name of the third party petitioner as defendant with reading in the title suit 46 of 2002 on or before the next date fixed. But the suit has been revived. It is when second appeal is over in this honorable court. The execution proceeding is going on, partly executed by partition and the related job on the corrected. Now the suit has been revived. And even my lord, if the opposite party number 1 has any grievance, my lord, he has the remedy to appear in the execution proceeding under order 21 rule 99 or file a separate suit. No problem. This is this is a partition suit, my lord, amongst the sharers, illegal heirs only. So, my lord, at this
Partition, so third party have filed a petition.
My lord. No, suit is over, my lord. The second appeal is over.
No, that's all right. In execution petition, they have filed a petition. Execution proceeding, they have filed a petition.
A petition, but suit has been revived by the learned trial court. Your lordship has seen the order, my lord. At page 121.
Where is that petition?
A petition is at Page 108. If they contest the execution proceeding, I have no objection, my lord. Petition of the petitioner third.
No, in the execution proceeding, they could have filed an application.
Under order 21 rule 99.
Yes.
Or they could have filed a separate suit. No, there is no bar, my lord. How the suit can be revived, my lord? It is already disposed of. Decree passed.
Now at what stage it is pending?
Pending, my lord, for inserting their name by your amendment, my lord. The DA is directed to insert the name of the third party petitioner as defendant with reading in the title suit number Iman on or before the next date. So at this stage, my lord, my prayer will be, my lordship will examine the matter, definitely examine the matter, my lord. Then the notice go, my lord, and in the meantime, this order.
Heard Mr. KKD, Lord and Counsel for the petitioner. Correctness or otherwise of the order dated 31/5/2025 passed by the learned civil judge.
Junior Division
Junior
1.
Division number 1, Dhuri in major case number 98 of 2025, arising out of title suit number 46 of 2002, is challenged in this petition under Article 227 of the Constitution. Yeah. Peruse the petition and the documents, lesson record, and also peruse the impugn order dated 31/5/2025. Let notice be issued to the respondents, returnable in 4 weeks, the be taken by registered post with AD and also by usual process within a week from today. Mr. Day, learned counsel for the petitioner submits that the learned court below by impugn order dated 31/5/2025 has allowed the petition number 115 of 2025 filed by the respondent hearing. Under order 1 rule 10 between bracket 2 CPC, read with section 151 CPC, for adding him as as a party in the suit in TS number 46 of 2 for proper adjudication. But Mr. Day submits that title suit number 46 of 2002 has already been disposed of, and against the judgment and decree passed in the title suit number 46 of 2002, one regular first appeal was filed, being first appeal number, what is the number?
21 of 2012.
21 of 2012, and white judgment and order dated
19/10/2012.
19/10/2012, the learned civil judge, senior division, Dhubri has affirmed the judgment and decree passed by the learned trial court, and against the said judgment and decree passed by the learned first appellate court, the respondent preferred one second appeal, regular second appeal being RSA number
112 of 2016.
112 of 2016, and the said RSA was also dismissed by this court by order dated
28, 2024.
28 of 2022, 2020, 2024,
24.
2024. 2020. And the petitioner herein has initiated one execution proceeding in execution case number
10 of 2012.
10 of 2012. And in the said execution proceeding, now where this petition was filed? 117 of 2025.
Civil Judge Junior Division.
No, in the execution proceeding or in the title suit?
Execution process. My lord, it says the TS number 46 of 2012. Title suit, my lord.
Title suit.
Title suit.
No, in the title suit. In the title suit, which has already been disposed of. And instead of filing the petition in the title suit number 46 of 2002, the respondent here, being the third party, would have filed on application under order 21 rule 97.
Or no, they file application under order 1 rule 10.
No, they file it, but
they could have filed
according to you, it should have been filed under
order 21.
order 21 rule 97.
99.
Rule 99 CPC. 99 CPC. And as such, the impugned order passed by the learned trial court suffers from manifest illegality, and therefore Mr. Day has contended to stay the same till disposal of this petition. Taking note of the submission of Mr. Day, learned counsel for the petitioner, and also considering the facts and circumstances of the court, there appears that I find substance in his submission, and accordingly, the impugned order dated 31/5/2025 stands state till returnable that list of the province.
That is for admission, item number 21, 100 meter.
Mr. Day, is there any development?
Instruction was in a sealed cover was given to me.
Mr. Day, you please go through this instruction. And you appraise this court after some time. So these are regulations, rules and regulation, otherwise also he has to follow.
Yes, my lord.
Okay, anyway, you go through it in and obtain instruction, you let this court know at 2 p.m. Do you have any extra copy of this
My
instruction?
lord, I have just been given a soft copy to me. I can give him soft copy to him. Soft copy I can give it to him.
Lordship may fix it tomorrow or day after tomorrow in that case, if not inconvenience.
My lord, we can finish it off because I have just seen the instructions. I think the appeal was allowed.
No,
That
you have 1 hour time.
Lordship, I'll try.
You obtain instruction, we will close the matter today itself.
at 2 p.m. my
At 2
lord.
p.m.
Adjourned.
They have allowed your prayer,
They allowed the prayer, my lord.
but you have to follow the regulations.
Regulations, rules and regulations.
Rules and regulations.
File number 22, parted matter.
You have your number. I cannot WhatsApp it to you. Yes.
If Lordship obliges, kindly can it be taken after some time, Lordship? Mr. Puya is on legs and one Lordship. Much obliged, Lordship.
23, parted matter.
No, I got the reading. Matter may be closed, my lord.
Matter may be closed.
Yes, ma'am.
You have got the salary,
Yes, ma'am. Area salary.
area salary. Heard Mr. A.J. Apia, learned counsel for the petitioner. And Mr. P.N. Sharma, learned standing counsel for the respondents in elementary education department. Mr. Apia, learned counsel for the petitioner, made a statement before the court that the petitioner has already received the area salary and his grievance has been redressed and there is no live issue to be decided in this petition, and therefore he submits that this petition may be closed accordingly. Taking note of the submission of Mr. K.J. Apia, learned counsel for the petitioner, this petition stands closed.
Most obliged.
24 and 25.
May I please, Lordship, we need them 2 weeks time to file our affidavit in reply.
Okay, art means
A Begum.
A Begum, learned counsel for the petitioner. And next sir, every for respondent number.
Respondent number 4.
Respondent number 4, Mr. Sharma for respondent number.
I am for respondent number 1. I am for respondent number 1, 3, 5 and 6.
1, 3,
5, 6 and 7.
1, 3, 5, 6 and 7.
Lord.
The learned counsel for the petitioner submits that she may be granted 2 weeks time to file a reply to the affidavit in opposition filed by respondent number.
Respondent number 4.
Respondent number 4. Yes. 4. There is accordingly allowed. Places a less the matter after 2 weeks.
Numbers 26 to 28.
Much obliged.
May I please, your lordship? Can this matter kindly be taken some other day, lordship? Otherwise, the LCR has called for his receipt today.
LCR has been received.
Yes.
Mr.
BB
Mr.
BB Kapoti.
Learned counsel for the petitioner and Mr. A.K. Gupta for respondent number.
My lord, in item number 26, I am appearing for respondent number 4 to 7 and 9.
4, 2, 7 and 9. 7 and 9. The learned counsel for the petitioner submits that the matter may be taken up on some other day. There is accordingly allowed. Dismissal is the matter when? After?
After 2 weeks.
After 2 weeks. There allowed.
Obliged.
Right, please, your lordship. Lordship, here, lordship, the premium check got dishonored due to insufficiency of fund, my lord. And accordingly, the owner of the vehicle was informed. The lordship on the last occasion had asked me to produce the letter addressed to the insured, I mean, the owner of the vehicle. So that letter I'm producing today, lordship. It was on lordship 26/2025. Lordship had asked me to produce the letter addressed to the owner of the vehicle. This letter was exhibited, lordship. My lord, by this letter, the two aspects were informed to him regarding the cancellation of the policy and the dishonor of the check issued by him.
Heard, Mr. Olita, learned counsel for the appellant. In this appeal, under section 173 of the MP Act, the appellant, United India Insurance Company Limited, has challenged the judgment and order dated 18/3/2025 passed by the learned member, MSCT number 1, Kamrup M. at Guwahati, in MSC case number 1113 of 2020. Is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 48 lakhs 2,091 as the compensation to the respondent here. Where is the memo of appeal and the grounds mentioned therein? And also peruse the impugned judgment and award dated so and so. Admit issue notice to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within our report today. Call for the record from the learned tribunal. List the matter after 4 weeks. So this stay order we will consider on next date.
Lordship, may I pray for at least till returnable date, lordship? May I pray for stay in the judgment, at least till returnable date, or the respondent appears, my lord. We'll take steps on this IA also.
In I also issue notice. But do you have any proof So delivery of this letter to the respondent?
In fact, no, my lord. That was not exhibited. That was not exhibited, lordship.
Then
Proof of delivery, but it was sent in the address furnished by him in the policy as well.
where is the postal receipt to show that you have posted this letter?
No such material is there, lordship.
Huh?
There is no material, sir. That's it.
Then here, pair for stay of the MP judgment and award will be considered on next day. You want to take back this?
Have the copy, lordship. I have the copy.
For admission, part admitted.
Lord, I am sorry, my lord, I was on leg, my lord.
Okay, no problem.
My lord, my lordship was pleased to hear the matter on length, my lord. Previous occasion, my lord, the issue is as regards the, my lord, regularization of the petitioner. Service, my lord, and which the finance department has objected to the same, my lord. And initially, my lord, my lordship was also pleased to direct me to file an additional affidavit, my lord, to bring into the record the connected schools, my lord, wherein I was initially appointed and subsequently, my lord, I was transferred to an school, the status of both the schools, my lord. My lord, I have inquired and verified, and my lord, have also brought on record by an affidavit, my lord. Initially, my lord, when I was appointed in the Thokro High School, my lord, that school was in a venture stage, my lord. That's why the managing committee has the power to appoint me, my lord, in that categories of school at that relevant period of time, my lord, when I was initially appointed. Subsequently, my lord, I had been, my lord, adjusted in a school that is called Indira High School, my lord, which had been provincialized in the year 1991. And that school, my lord, I had been adjusted by a conscious order of the government, my lord, on the strength of an adjustment order that the, my lord, I should be adjusted in a particular vacant posts, my lord, and that adjustment order is also there, my lord. Now the department says, my lord, that their stand is that, my lord, that the, as my initial appointment was not following the due procedure of law, that's why, my lord, I cannot be regularized, my lord. But my contention, my lord, is that, and respectful submission before my lord is that, my lord, as my initial appointment was in a purely in a venture school, so, my lord, therefore, there is no violation of any recruitment rule. At that relevant period of time, my lord, no rule was governing.
So when your service was service was adjusted
My lord,
in another school,
another school, my lord.
so whether that school was at that point of time answer school or provincialized?
Provincialized, my lord, provincialized.
Provincialized.
Provincialized, and that's why, my lord, subsequently, I had been regularized also by the department, my lord, but that.
When?
Yes, my lord, it was a long back, my lordship was pleased to hear. For that, my lord, I am again troubling my lordships with the initial order of my appointment, my lord. Just for a moment, at page 30, my lord.
Page 30 is
Of
the
my
first order.
first order of my appointment, my lord. Just few annexure will clarify, my lord. Page 40, my lord, is the appointment letter. You are hereby appointed as a Hindi teacher in Thokro High School as an honorary basis by resolution of the managing committee number 1 dated 3rd of February 1999. Hence, you are requested to join in your service within 15 days from the date of issue of this order. So, my lord, this appointment order had been issued when this school, Thokro High School, was purely in a venture stage, my lord, which will reflect from my additional affidavit, my lord, which I have annexed, my lord. The provincialization order of this Thokro High School is dated, my lord, 3rd of June 2013. Page 88, running page, my lord. My lordship has got the page, my lord, is at page 88. My lord,
Yes.
in pursuance of the government letter number dated so and so, 342 numbers of teaching and non-teaching staff have been created for Gwalpara district under the provision of the Assam Vansar Educational Institution, Provincialization of the Services Act 2011 as amended. The under-mentioned post hereby allotted to Thokro High School District Gwalpara with effect from 1/1/2013, which was recognized on 1/1/1993. Now, my lord, this provincialization effect has been given with effect from 3rd of June 2013, my lord, and effect had been provided from 1/1/2013, my lord. Now, my lord, what has happened before this provincialization order could be, my lord, effected? I was, my lord, removed from this school by the government by way of an adjustment order. My lord, may be pleased to find that order, my lord. Page 32, my lord, of my writ petition, my lord, Annexure 3.
Yes.
My lord, this is an order issued by the government, additional secretary to the government of Assam Education Secondary Department, the inspector of school so and so, regularization of service by way of adjustment. With reference to the subject cited above, I am directed to forward herewith an application along with its enclosures received from so and so honorary Hindi teacher of Thokro High School in the district of Gwalpara regarding regularization of his service, which is self-explanatory. You are therefore requested to take necessary action for regularization of his service with prospective effect by way of adjustment against the vacant post of Hindi teacher of Indira High School in your district immediately. So, my lord, may kindly appreciate that this is a conscious letter issued by the additional secretary to the government of Assam Education Secondary Department to the Inspector of Schools way back in the year 2001, my lord. Responding to this, my lord, at page 33, Annexure 4, this order had been issued, my lord. May I read, my lord? At page 33, my lord.
Yes.
Government of Assam, Office of the Inspector of Schools, Gwalpara District Circle, Gwalpara, in pursuance of the government letter number so and so dated 8/1/2001, received from the Secretary to the Government of Assam Education Department, Dispur, Guwahati 6, the service of MD so and so, honorary Hindi teacher of Thokro High School, is hereby regularized by the way of adjustment as Hindi teacher senior in the scale of pay of rupees so and so, other allowances as per the rule admissible with immediate effect against the vacant post of Indira High School by Sri Ranjit Kumar Talukdar, head teacher, senior, transferred, my lord. So, my lord, by way of this order, I had been regularized by way of an adjustment way back in the year 2001 by way of an order dated 6/2/2001, my lord. And, my lord, thereafter, I have also received salaries for 30 months, my lord, continuously. Now, this is a letter, my lord, Deputy Secretary to the All Inspector of School, submission of particulars of so and so. These particulars have been, my lord, sought for. Now, my lord, when I was working, then suddenly, my lord, my salary had been stopped. And thereafter, my lord, I had approached before this honorable court, my lord. The order passed is at page 39, my lord. The first writ petition which I have preferred, my lord.
Page number?
Page number 39, my lord. WPC 77702, my lord. This is an order on 18/2/2002. Heard Mr. So-and-so, learned counsel for the petitioner, let the records be called for. Let a rule issue calling upon the respondent to show cause as to why. My lord, the operative part, my lord, may be pleased to find. At page 40, last paragraph, also notify the parties that the prayer for interim relief shall be heard on the next returnable date till such hearing the operation of the impugn order dated 3/9/2001 and 19/10/2001, Annexure 8 and 9, so far as it relates to the petitioner, shall stand stayed. So, my lord, the order by which, my lord, my salary had been interfered with, my lord, that has been stayed by of this interim order, my lord. Now, my lord, may be pleased to find the pursuant to the order, interim order, my lord, at page 41. Peruse the, my lord has got, my lord, page
Yes.
41. Peruse the Honorable High Court order dated 18/2/2002 under so and so. Peruse the application dated 28/2/02 received from the petitioner Sri so and so. Peruse the report finding the petitioner Sri Altaf Hussain was appointed by the managing committee of Thakro High School, which is an ad hoc school, and subsequently his service was adjusted in Indira High School, Gwalpara, against a vacant post of Hindi teacher. As per the records, the petitioner so-and-so has not selected candidate for appointment in the provincialized school. Therefore, adjustment of his service in Indira High School was wrong and illegal. In view of the above finding, the order of adjustment of service of so-and-so in Indira High School is hereby cancelled. If it has any lawful ground for the illegally claiming the post which he is holding, he may file an appeal before the undersigned within 15 days, and that will be considered as provision of existing rules. So, my lord, from this order, it can be, my lord, find that my adjustment order had been cancelled, my lord. Thereafter, my lord, I again, my lord,
You tell me before passing this order,
my lord.
whether any
Hearing.
opportunity of hearing was applied?
No, my lord, because, my lord, only basing on, my lord, this, when I submitted this interim order, my lord, this order has been subsequently passed, because if my lord goes through, my lord will not found any finding regarding my hearing also was not there, me. Now, secondly, my lord, pursuant to this order, my lord, I have abide by and complied with, an appeal had been preferred before the Director Secondary Education, my lord, way back on 17/9/03, my lord. 3903, my lord, is at page 43, Annexure 9, my lord. When, my lord, this appeal was pending, was not considered, then, my lord, finding no other alternative, my lord, I again approached before my lordships, my lord, is at page 48, Annexure 10, order, my lord, passed by this honorable court. My lord, I can skip the first paragraph. From second paragraph, it is relevant, my lord. Mr. Thomas, the learned standing counsel, submit that since the appeal is pending before the appellate authority, it will be appropriate to issue a direction to dispose of the same. Considering the submission made by the learned counsel for the parties, I am of the considered opinion that the writ petition need to be detained here. Need not to be detained here. Instead, it is provided that the Director Secondary Education Assam shall take on record the Annexure 17 appeal dated 03/09/03 and dispose of the same in terms of the Annexure 16 order dated 21/8/03. The appeal shall be disposed of within a period of 2 months from today. Mr. So-and-so, the learned standing counsel shall make necessary communication with the director for compliance of the order. Till disposal of the appeal within the stipulated period of 2 months, the services of the petitioner shall not be disturbed, if not already dispensed with, pursuant to the impugn Annexure 16 order dated 21/8/03. The petitioner may obtain the certified copy of this order and produce the same before the said director with a copy of the writ petition and its enclosure for his necessary follow-up action. It is submitted by the learned counsel for the petitioner that in terms of the interim order passed by this court, the petitioner has been continuing his service but has not been paid his salary. This aspect of the matter shall also be considered by the Director Elementary Education, Assam. So, my lord, this was a very clear direction to dispose of my appeal with the interim protection which was also there, my lord. Now, is at page 52, my lord, is the order by which, my lord, the appeal had been disposed of, my lord. Since the letter number, my lord has got at page 52, my lord. Since the letter number so-and-so dated 20/06/2012 from the government of Assam in the secondary education department The government has asked the undersigned to dispose the appeal petition by issuing a speaking order, hence this speaking order. Sri Altaf Hussain was appointed by the managing committee of the Thokro High School, District Gwalpara, government by order number so and so dated 8/1/2001, asked the Inspector of School Gwalpara to take necessary action to regularize his service by way of adjustment against the vacant post of the Hindi teacher of the Indira High School. Accordingly, the Inspector of School Gwalpara, by order number so and so dated, adjusted Sri Altaf Hussain against a vacant post and he joined in Indira High School on 1/3/2001. He received salary for 30 months. Thereafter, his salary was stopped. The director, by letter number dated, cancelled the order of adjustment. Sri Altaf Hussain filed WPC number so and so and the Honorable High Court provided that the services of the petitioner shall not be terminated if not already terminated by the appointing authority. The WPC number so and so was finally disposed of on so and so, asking the director to dispose his representation dated 3/9/2003 by an order dated 21/8/2003. The representation dated 3/9/2003 could not be put up by the branch. Instead, Sri Altaf Hussain filed a fresh representation on 2/6/2012, attaching a copy of the representation dated 3/9/03. The Inspector of Schools, Gwalpara, has reported that Sri Altaf Hussain is still serving as Hindi teacher in Indira High School. As his service not discontinued after the order of the Director Secondary Education dated 21/8/2002, and instead he was allowed to serve, the petitioner has stated that his family will perish if his service is discontinued after serving the school for so many years. I had perused the order dated 5/1/2006 passed in WPC number so and so. Although in the last line of the order it is mentioned that the Director of Elementary Education will consider his case, but in the 9th line of the order it is provided that he will prefer appeal before the Director of Secondary Education. It transfers from the order of the petitioner shall file a appeal application before the authority, and accordingly he filed the representation, but no order is seen to have been issued on the appeal. Seen the report of the Inspector of School Gwalpara dated, which is at so and so, it is also reported by the Inspector of School that the petitioner has not received the salary since August 2003. Considering the plight of the petitioner and considering the facts of this office did not take any prudent action to terminate his service, government may consider his case on humanitarian ground to regularize his service with prospective effect with his representation of Sri Altaf Hussain, Hindi teacher of so and so, is disposed of. My lord, may kindly note the date of this is on 25th of July 2013, my lord. So, my lord, from here it transfers that I was not terminated, and my lord, government was also not in a mood, my lord, for my termination, my lord, considering the aspect and manner by which, my lord, I was allowed to continue, my lord. Now, at the next page, my lord, may kindly, is a letter issued by the Deputy Secretary to the Government of Assam, my lord, to the Director of Secondary Education regarding regularization of service of so and so. With reference to the subject cited above, I am directed to request you to furnish a proposal for regularization of service in respect of so and so of Gwalpara, along with the finance SIU format 1 and 2 and creation number at an early date. So, my lord, this is the format which they have annexed, my lord. And by the director, my lord, by annexing the SIU format at page 54, my lord, has written to the government, my lord. With reference to the subject cited above, I have the
all right, next stage.
Next stage, my lord, may be pleased to find, as my process, my lord, for regularization was on a halt, my lord, was not proceeding further. Therefore, my lord, I again approach before my lordship is at page 57 order, my lord, is at page 58, my lord. This is the order, my lord, by which notice had been issued with an observation that pendency of the writ petition shall not be a bar for regularizing the service, and this petition, my lord, ultimately came to be disposed of, my lord, by this honorable court at page, my lord, 59, annexure 15, my lord. My lord, the operative part is at page 60. Small order, my lord. Heard Mr. So-and-so, the learned counsel for the petitioner, and Mr. So-and-so, Education Department, Government of Assam, Standing Council, Finance Department, when this matter was taken up for consideration, it has been submitted by the learned counsel for the petitioner that the petitioner will be satisfied if a direction is issued to the respondent authorities to consider the proposal submitted by the Director of Secondary Education Assam for regularization of the service of the petitioner as a Hindi teacher in the Indira High School, Gwalpara, as proposed to the Secretary to the Government of Assam Education Secondary Department by this letter dated and take appropriate action relating to the claim of the petitioner for regularization within a time-bound period. In view of the above submission, present writ petition is disposed of with a direction to the respondent authorities, more particularly respondent number 1 to examine the said proposal as submitted by the Director of Secondary Education Assam for regularization of the service of the petitioner as a Hindi teacher in Hindi High School, Gwalpara, in accordance with law, so that in the event the petitioner is otherwise found entitled and eligible, necessary benefit of regularization may be given to the petitioner. The above exercise shall be completed within a period of 6 months, my lord, and accordingly, my lord, at page 61, the process has been again, my lord, started. Annexure 16, my lord. This is a letter issued by the additional director to the commissioner and secretary, submission of the action taken report. With reference to this subject cited above, I have the honor to submit herewith an action taken report filed by so and so of Gwalpara. This is for kind information and necessary action of the government. This is the report, my lord, is at page 62, annexure 17, my lord.
Yes,
My lord, the entire facts has been narrated here in history. My lord can skip the paragraph 1, 2, 3, my lord. 5 can also be, my lord. 6 is the relevant, my lord. As per record, it is seen that the matter is related with the Honorable High Court order. It is not known to the reason in the year 1999 under what rules oblique provision the SMDC of the concerned school has made appointment on honorary basis. Now the matter is legitimate right of the petitioner as per the Honorable High Court order dated so and so, so and so. The same is enclosed herewith. The necessary documents are enclosed herewith. The matter is placed for necessary consideration of government for further avoiding of the legal complications. Now, my lord, the judicial department has also been sought for at page 63, my lord. It is a court case related matter in WPC filed by Altaf Hussain regarding regularization of service as a Hindi teacher in the Indira High School, Gwalpara. In this connection, a speaking order issued by the Director of Secondary Education is so and so, so and so. Now, notes and orders from page so and so related to link file number so and so may also be perused. Now, the Judicial Department is requested to furnish their legal views on the matter of regularization of service in respect of Altaf Hussain as a Hindi teacher in Indira High School, Gwalpara. So, my lord, this is the Education Legal Cell Department, my lord, opinion. My lord can skip the few part. The last paragraph is relevant, my lord, is at page 64, annexure 19, my lord. Since admittedly service of the petitioner was not dispensed with and thereby made him to work for a prolonged period more than 20 years, and therefore non-consideration of his case would cause great injustice. However, there may be legal difficulties in regularizing his service as proposed. Therefore, the department may consider to adjust his service against the proposed sanction post, and there may not be any difficulty since post is available and there are numerous instances of such adjustment of services of honorary teachers in Assam. Accordingly, the department may consider his case for adjustment prospectively on humanitarian consideration as proposed, and this may be done in substantial compliance of the Honorable Court's order dated 4/12/2019 cited above. The department may act accordingly. This has the approval of the LR Assam. Now, this is the difficulty, my lord, is at page 65, annexure 20, my lord. Every department has cleared, my lord, for my regularization, but the obstruction has been made by the finance department, my lord. Finance department observed that under what provision of rules oblique acts, the education department has submitted this proposal for regularization of the service of so and so who has been illegally appointed. So, my lord, where from the finance department come to a conclusion that how I was appointed illegally, that finding is missing in their note, my lord. So, therefore, this is the communication as per the previous views of the finance SIU department by and dated so and so. Now, my lord, the last letter is a communication, my lord, made by the government to the Director of Secondary Education, Assam, wherein, my lord, the Finance Department's this note has been referred and express its inability, my lord, for my regularization, my lord. That's why, finding no other alternatives, my lord, I am again before my lordships, my lord, that the view which has been adopted by the, my lord, Finance Department appears to be, my lord, is in conflict with the other views which has been taken by the education as well as, my lord, the law department of the government, my lord. And the secondly, my lord, my limb of argument, my lord, is that, my lord, when I was appointed initially, my lord, the law has been well settled regarding the regularization concept, my lord. In a, my lord, admittedly in a provincialized school, my lord, there is a recruitment rule, my lord, governing the service condition for entry into the service. Now, my lord, when the school was in a venture stage, my lord, that Thokro High School, my lord, wherein I was appointed, was purely in a venture stage, which, my lord, can be arrived from the, my lord, provincialization order, which I have just brought into my lordship's kind notice, my lord, is at page 88. It has been provincialized only in the year 2013. And I was appointed, my lord, way back in the year 1999, my lord. So therefore, the stand of the government that I was provincialized, I was appointed in a provincialized school, my lord, I don't think that it will survive, my lord. So therefore, my lord, no doubt, my lord, from this school, I have been again, my lord, for the interest of my service, my lord, for the government's power, my lord, what power they have exercised, I had been shifted to another school, my lord, in a vacant post, my lord, admittedly in a vacant post, wherein, my lord, my service has been adjusted for the purpose of regularization. Although, my lord, that regularization has been later on interfered with, but, my lord, till date, there is a no clear-cut order that I have been terminated or they have debarred me that I should not go to Indira High School or, my lord, I should not perform my duties. Even my salaries has also been paid, my lord, for the period of 30 months, my lord. This creates my legitimate expectation, my lord, that in near future, my lord, I will get something, and who is from the various communications, my lord, of the government. Even there is a proposal has also been sent by the government, my lord, for the purpose of my regularization. All these actions of the government, my lord, has created my legitimate expectation that, my lord, my service would be retained. And I have been allowed to work for more than now, my lord, from 1999 to 2025, my lord, it is around 26 years. My lord, valuable year they have extracted and consumed also, my lord, by the department. Now, what they are doing, my lord, they are now going to throw me out, my lord. Without regularizing, now I am on the verge around 55 years of age, my lord. I have my family, my lord, my children and entire families depend on this with an expectation that my service would be protected, my lord. So, my lord, this honorable court as well as the honorable apex court, my lord, also in the katana of judgment from Uma Devi to Nihal Singh, my lordship is well aware, my lord. In various judgments, my lord, it has been said that, my lord, that when a person render his service for more than 10 years, in paragraph 55 of Uma Devi, it is very clear, my lord. If a person render his service for more than 10 years, my lord, in a substantively vacant post, my lord, then he is entitled for the purpose of regularization. That has also been reiterated in ML Kesri's judgment, my lord, of 2010, and then again in Nihal Singh's case, my lord. And recently, my lord, the Honorable Apex Court in a judgment, my lord, is a very recent judgment of, my lord, 2024, wherein, my lord, the Honorable Apex Court has says that.
What is the citation?
Citation, my lord, is 2024 SCC Online SC 3826, my lord. 2024 SCC Online SC 3826. My lord, my lord can have a copy, my lord, of this judgment, my lord. Wherein, my lord, the stand of the Honorable Apex Court has very clearly says, my lord, even the entire issues of Uma Devi, ML Kesra, which I have relied on, my lord, has been reiterated here. Wherein, my lord, the Honorable Court has says that the allowing a persons continuously, my lord, without giving any salary is amounting to forced labor, my lord. Is a forced labor, and in that manner, my lord, the government cannot be allowed to work, and so therefore there is a direction for, my lord, for the purpose of regularization of those sets of employees, my lord. If my lord may be pleased to take up the last few paragraphs, my lord. I am reading from paragraph 25, my lord, if my lordship allows me, my lord. Paragraph 25.
Yes.
It is a disconcerting reality that the temporary employees, particularly in the government institution, often face multifaceted forms of exploitation. While the foundation purpose of the temporary contracts may have been to address the short term of the seasonal needs, and they have increasingly become a mechanism to evade long-term obligations owed to employees, and these practices manifest in several ways. Misuse of temporary labor, employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as a temporary or contractual, even when their roles mirror those of a regular employees. Such misclassification deprives the worker of the dignity, security, and benefits that regular employees are entitled to, despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or notice, as seen in the present case. This practice undermines the principles of natural justice and subjects workers to a state of the constant insecurity, regardless of the quality or duration of their services. Lack of career progression. Temporary employees often find themselves excluded from the opportunities for the skill development, promotions, or incremental pay raises. They remain stagnant in their roles, creating a systematic disparity between them and their regular counterparts, despite their contribution being equally significant. Using the outsourcing as a shield, institutions increasingly resort to outsourcing the rules of performed by the temporary employees, effectively replacing one set of exploited workers with another. This practice not only perpetuates the exploitation but also demonstrates a deliberate effort to bypass the obligation to offer a regular employment. Denial of the basic rights and benefits. Temporary employees are often denied fundamental benefits such as a pension, provident fund, health insurance, and paid leave, even their tenure of the spans of the decades. This lack of social security subject them and their families to undue hardship, especially in the case of illness, retirement, or unforeseen circumstances. While the judgment in Uma Devi sought to curtail the practice of the backdoor entries and ensure the appointments adhere to the constitutional principle, it is regrettable that its principles are often misinterpreted or misplaced to deny the legitimate claims of the long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted, and when the institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal but merely lack adherence to the procedural formalities. Government departments often cite the judgment in Uma Devi to argue that no vested rights to the regularization exist for temporary employees, overlooking the judgment explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against the employees who have rendered indispensable service over decades. In light of this consideration, in our opinion, it is imperative for the government departments to lead by example in providing fair and stable employment, engaging workers on a temporary basis for extended period, especially when their roles are integral to the organization's functioning, not only contravenes the international labor standards but also exposes the organization to the legal challenges and undermines the employee's model. By ensuring the fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote the job security, and uphold the principle of justice and fairness that they are meant to embody. This approaches the aligns and with international standards and sets a positive precedent for the private sector to follow, and thereby contributing to the overall betterment of the labor practice in the country. In view of the above discussion and finding, the appeals are allowed. The impugn order passed by the High Court and the tribunal are set aside, and the original application is allowed to the following extent. The termination order dated are quashed. The appellant shall be taken back on duty forthwith and their services regularized forthwith. However, the appellant shall not be entitled to any pecuniary benefits, back wages for the period they have not worked for, but would be entitled to continuity of service for the said period, and the same would be counted for their post-retirement benefits. There shall be no order as to costs. My lord, relying on the judgment, my lord, what I respectfully beg to submit, my lord, this is a very clear-cut, my lord, distinction has been made with all respect by the Honorable Apex Court, my lord. What I have seen, my lord, that the government often come up, my lord, with this Uma Devi judgment and make submissions before my lordships, my lord, that basing on the Uma Devi, there is a bar for regularization. But my lord, Uma Devi has also said otherwise also, my lord, that when and under what circumstances, my lord, an incumbent should be regularized, my lord. Here is a case. This is a case of contractual employees. But in my case, I am not a contractual, my lord. I have been appointed, my lord, without violating any rule, my lord. My initial appointment without any violating any rule, even, my lord, neither in the category of illegal or irregular I fall, my lord. My appointment, many of the employees, my lord.
Okay.
My lord, my lord.
Yes, madam, what is your submission?
Lordship, in page number 72 of our affidavits, there are the findings and the opinions, Your Lordship.
Page number
72.
72.
Yes, Your Lordship. Page number 72 below
of
Your
the
Lordship.
petition.
Below Your Lordship. No, Lordship, of our affidavit. Running page 72, Your Lordship.
No, there is a mismatch. You are for respondent number 3.
Secondary.
For the secondary department, Your Lordship.
Yes, 3.
Yes, Your Lordship.
Your affidavit starts from 93 page number.
No, Your Lordship. My affidavit start from 67.
No, it is start from 93.
Lord, my respected friend is relying on an affidavit filed by the director, my lord, secondary education, my lord, on 21st of day to the
No, that is respondent number 3, director of.
Mamata Huzai's affidavit, my lord. Mamata Huzai, my lord.
Yes, that affidavit is of dated 3rd of October 2024.
My lord, correct, my lord.
That is in page number 72, Your Lordship. Next are R1, Your Lordship.
Yes.
Below, Your Lordship, there is the findings. And on the next page is the opinion, Your Lordship. So in the findings here, it says that the petitioner Altaf Hussain was appointed by the managing committee of Turko High School, which is an ad hoc school, and subsequently his service was adjusted in Indira High School, Walpara, against a vacant post of Hindi teacher. As per record, the petitioner Sri Altaf Hussain was not selected candidate for appointment of provincialization school. Therefore, adjustment of his service in Indira High School was wrong and illegal. In view of the above findings, the orders of adjustment of service of Mohammad Altaf Hussain in Indira High School is hereby cancelled. If he has any lawful ground for illegal claiming the post which he is holding, he may file an appeal before the undersigned within 15 days and with the will be considered provisions for existing rules, Your Lordship. We have already communicated, Your Lordship, with the Finance Department also. With communications.
Here is a case, Lordship, where the entry of the petitioner, that has in itself, it's illegal, Lordship. That is why we have regretted it, Lordship. Now, my learned friend has placed one judgment.
No, on what basis you were submitting that his appointment was illegal?
Lordship, that is coming from the Lordship because the appointment has been made. Lordship, Lordship, because we had asked for the record from the education department, wherein it has stated, Lordship. Page, Lordship, page 52 of the writ petition to 50. Lordship, that is the order passed by the Director of Secondary Education, Assam Kahili Pala, Lordship. Page 59.
Page 50?
It was a page,
Oh, yes.
page with a fuller. So here, Lordship, here is an observation. Lordship, I'll just go through the second para where Shri Altaf Hussain was appointed by the Managing Committee of Thorko High School, District Gwalpara, Government Right so and so dated, asked the inspectors who got
No, you come to this page number 32 of the writ petition, annexure number 332.
Yes, Your Lordship.
This is the letter issued by the additional secretary to the Governor of Assam Education Department,
Lordship.
right?
Yes, Lordship.
It was written to the inspector of school.
Inspector of schools.
And pursuant to this letter,
Lordship.
the inspector of school has regularized his service.
Lordship, then it was cancelled also pursuant to Lordship.
Cancel.
Yes, Lordship.
Whether an opportunity of being heard was afforded to him at the time of cancellation of this order?
No,
This
Lordship,
order?
that I am not aware, Lordship.
Then?
No, Lordship, here we were informed regarding whether he was illegally appointed or irregularly appointed, Lordship. He had given a service for which he is being paid.
While the file was sent to the finance department, whether you were supposed to examine that aspect of the matter?
No, Lordship, here, if the petitioner has been appointed, there has to be under some.
No, you answer my question whether finance department is to examine the legality or illegality of the appointment.
Yes, Your Lordship. Whether
You are
the proposal for it is for regularization, so the entire backdrop of the petitioner has to be examined, Lordship, at that moment. And if there's certain
whether the finance department is the authority to examine that is
for regularization, we'll have to give a final approval has to come through us, Lordship, because then a post has to be created for pensionary benefits. SIU approval will be required for that, Lordship. And now here is a case, Lordship, where the petition, Lordship, here no clear-cut direction has ever been given in favor. For regularization also, Lordship, there has been an observation on humanitarian grounds, Lordship. My learned friend had read it. I also went through it, Lordship.
No, forget about that humanitarian ground. On what basis the additional secretary has written this letter, annexure 3?
Susan.
Whether the petitioner approves the additional secretary?
Lordship, this I am not aware of, Lordship. Here, Such.
No, you tell me whether a government department can argue against the order of another department.
No, Lordship, for regularization, our approval, these are interdepartment communication, Lordship, whether or not they have they do not possess the necessary authority to regularize the service of the petitioners, Lord. So without the approval, if these are interdepartmental queries, Lordship, and here also no regularization order has been passed. You are therefore requested to take necessary action for regularization of his
No,
service.
the next order, next page, next up.
In pursuance of the service of honorary basis, Lordship. Yes, inspector of school is not the authority, Lordship, to regularize this. They do not have the authority to pass a regularization order, Lordship. And here, Lordship, I can place their judgment, Lordship, where the entry of this in like the entire entry into the service is only being questioned, Lordship. Whether or not the person is entitled to regularization, Lordship, there I can place judgments, Lordship. Tomorrow I can place. My learned friend has placed one judgment, Lordship, today. Lordship may allow me 1 day's time. I'll distinguish, Lordship. Here, because he is asking for regularization, Lordship. Here, our difficulty is his entry into service. That in itself is not.
No. Who has directed his service to be regularized in another school?
That is the authority.
By the
Here,
government, Miller.
By government.
By the government.
government in the education department.
No, this additional secretary has written the letters.
Yes, but Lordship, they have written a letter. They have informed the officer to take necessary action for regularization. Lordship, here.
Then accordingly, the inspector has regularized.
Milord, the inspector has acted on a direction of the government, Milord. It is at page 32, annexure 3 is very clear, Milord. This is a letter issued by the additional secretary to the government of Assam Education Secondary Department. I am directed, generally, Milord, this has been written because it has not been issued by the commissioner and secretary. That's why, Milord, the commissioner and secretary of the department directed the additional secretary to issue this letter. Accordingly, Milord, he acted on behalf of the state of Assam, has issued this letter directing the inspector of school to regularize me. That is the proposition of law.
Lordship, if my learned friend can show somewhere where they have taken the approval of the finance department, because this will bring on.
Milord, why I will show, Milord, it is there, the interdepartmental communication, it is not
Lordship,
my
here,
duty, Milord, to satisfy.
These communications only imply that.
And secondly, Milord, my learned friend is hesitating that my initial entry is illegal. My initial entry is in a venture school, Milord, which I have demonstrated from record, Milord. So therefore, Milord, there is no question of, Milord, illegal.
Please, sit down. Yes.
Now, here, Lordship, my learned friend is nowhere there. Even all the communications, the government has only asked for consideration. That too on humanitarian ground for regularization of the petitioner, because he has been serving for a very long period of time, for which he is getting his wages also. Now, when the aspect of regularization comes into picture, Lordship, because that will bring there'll be other sources also, Lordship, because this will affect the rights of other similarly situated people also. So the entire entry and the duties that the petitioner has performed, his entry into service, all has to be examined thoroughly to come to the conclusion whether or not he is entitled for regularization. I'm only speaking on the basis of regularization. The service which my learned friend, which the petitioner has put, for that he is allowed for which he is getting his salary. Now, when it comes to regularization, pension will come into play. All these other retirement.
No, first you tell me whether he is in service at present.
Lordship, that my learned
information is not available with you.
That is
not. I am continuing. I can produce.
No. Let him.
He is currently he's working. He is getting his salary also. Now only the
salary part.
He's not. He's not getting his salary, Lordship. Regarding that,
Mr. Soliha,
Lordship.
You are arguing without any basis.
No, Lordship. Here I am arguing on the topic of regularization.
So you come prepared.
Yes, Lordship.
So I will not.
Tomorrow, Lordship.
I will not allow you to argue in this manner.
Lordship.
You are nowhere on the record.
Lordship. No, Lordship will fix the matter tomorrow. I'll come prepared, Lordship. Today there's some difficulty. Let me go through the judgment which my learned friend has shown. I will, regarding I am only sticking to the topic of regularization, whether he's entitled to regularization or not, Lordship.
No, the petitioner was appointed in a venture school. Thereafter, his service was adjusted in one provincialized school.
Yes.
And he is nowhere responsible for the same.
No, yes.
The respondents are responsible for the same.
Yes, Lordship. That
And ultimately, the venture school was provincialized in the year 2013. 13.
After my shifting.
Yes.
Had he not been transferred to another, adjusted in another school, his service would have been provincialized in the year 2013. And he would have been getting his salary regularly since 2013.
Lordship.
Now, who has created the mess?
Lordship, here, that is.
Who is responsible for the same?
Now, Lordship, here, that is where in such situations, where without the proper channeling and without the proper approval, when such decisions are being made, in what line, what observation the Honorable Court has made, Lordship, that judgment I want to place on like tomorrow, Lordship. Because there are other cases also where the person who is not authorized to regularize the service of petition of people, Lordship, they have authorized. So what happens in these situations regarding regularization, that I want to place, Lordship. Today I have not come prepared with the statement, Lordship. In the case where an authority which is not empowered to regularize, and when they regularize, what happens, Lordship, I'll place that.
Hindi teachers, Hindi assistant teachers, teacher in Hindi subject, who will regularize his service? Who is the appointing authority?
Appointing authority.
Milord, under the rules in a secondary school at this moment is inspector of schools. Milord.
Inspector.
Yes, sir.
Then what wrong with that?
No. Whether, Lordship, whether the inspector, whether they can regularize, Lordship, appointing authority has appointed, for which, whether rightly or wrongly, that's why the petitioner is going to get his salary. Now, whether the inspector of school has the authority to regularize the service of the petitioner, Lordship, I'm on that. I'm not on the part whether or not, since he has appointed rightly or wrongly, petitioner might be entitled to the salaries because of the services. Now, whether inspector of schools, when he has appointed, whether his appointment will make him eligible for regularization, that is pension, whether that will bring.
That's all right. We'll hear you.
Yes.
But in the meantime, he will release his salary.
Lordship, yes, that can be done by the authorities in the education department, Lordship, because.
Yes. He will release his salary. He has been working without any salary. Tell me within 2 weeks whether you will be able to pay his salary, entire salary. Pardon?
After 2 weeks.
Okay, we will finally hear and dispose of the matter.
Lordship,
Tomorrow.
for hearing, yes, tomorrow, Lordship, I fix it for hearing and Lordship may pass.
Okay. Heard Mr. Pierre Moya, learned counsel for the petition, Mr. Soliha for the respondents in finance department, and Ms. Peranti for respondent number
1, 2,
1 and 2.
1, 4, yeah.
No, 1, 3 and 4. 1,
Yes,
3 and
yes.
4.
What
Heard
is
him
the finance?
the matter tomorrow.
To opponent.
Oh, further hearing.
Yes.
Tomorrow, Milord?
Tomorrow at 2 p.m.
Yes, yes.
Timing item 21.
Obliging, highly obliged.
I've shown him the copy, my lord. He has seen it. My lord.
Yes, I'm grateful for this lordship, for your lordship intervention, my lord. But two aspects on which the minutes are absolutely silent, my lord. One is the change of supervisor, my lord.
You tell me, are you agreeable to the letter he has produced before the court today?
Yes, they have said they have terminated me by following the
You
due
cannot
process.
bargain in this way.
No, my lord,
You cannot bargain in this way. We will dismiss the petition otherwise.
No, my lord, they have said
that they have followed the due process of law, and that is why they are.
No, you were not supposed to question that aspect.
But my lord, the minutes are silent on the aspect
Now,
of.
now they have given you one opportunity, you avail it. And if you are not willing to avail it, then all right.
Lordship may just make an observation. They have
What
said that
observation? No.
as regards the pending fellowship, because for years I was there, my lord, and they without any notice and without any official order, they stopped my fellowship, my lord. That is one. And secondly, my lord, is that the change of supervisor.
My lord, on the point of fellowship, my lord, if he's arguing, then my lord, I will just submit first what the minutes have been given. Minutes have said that you will get your fellowship as per your norms. Whatever the norms are there, as per the norms, you will be, or the rules and regulations, you will get the fellowship. Now, that he was not been intimated.
Future fellowship, my lord.
With regard to what has not been intimated to him, that he has not been intimated, suddenly the fellowship has been stopped. That part may not be correct, my lord, because in the affidavit, in our affidavit, page number 161, para number 18, my lord, we have annexed a letter. Because, my lord, these aspects have already been taken care of by me also on that time, my lord. Now, by that letter, he was intimated that your monthly fellowship will be stopped because you are not coming to the university, you are not doing your job. So your monthly fellowship will be stopped. That was intimated to him.
Yes, that order for stopping the fellowship was on October 29, 2018. However, my fellowship was not paid from February 2018.
It was February 2018, my lord. The order is there. The letter is there.
No,
So whatever fellowship, whatever dispute.
Let us do one thing. He will file an application for releasing his pending scholarship, pending fellowship. And on receipt of the same, you examine the matter. And if he is entitled to any such fellowship, release it.
My lord, let this writ petition be closed now.
Yes, we will close.
And my lord, let him file it. They will consider it, whatever way
Yes.
my lord is. My lord, please.
Heard Mr. S. there, learned counsel for the appeal. Then Mr. A. B. there, learned counsel for the respondent number 1, 2, and 3. Then Mr. A. does for counsel number, learned counsel for the respondent number 4. Respondent number 4.
I am for 1, 2, and 3, madam.
Yes. Person to order of this court dated 9/6/2025. Mr. A.B. Day, learned counsel for the respondent number 1, 2, and 3, has produced the written instruction he has received from the aforementioned respondents. And perusal of the same indicates that the respondent number 1, 2, and 3 has taken a decision regarding the reinstatement of the studentship of the petitioner. However, subject to certain conditions.
And he is submitting an undertaking.
As laid down in the resolution in item number 1 of the minutes of meeting of the 187 Senate meeting held on 11/7/2025. And perusal of the aforementioned resolution, the aforementioned minutes of the meeting in respect of item number 1, which relates to the pair of the appeal of the petitioner, indicates that the Senate has considered the matter and deliberated at length, and based on the suggestion received from this court, the Senate has opined that his appeal for reinstatement of studentship may be considered on sympathetic ground, which will support his professional growth. Full stop. However, the Senate opined that Mr. Sunoyan Deka must submit an undertaking that he will follow the rules and regulation of the institute without fail for rejoining the PhD program. Further, the Senate has opined that his request for fellowship and part-time category conversion shall be as per the rules and regulation of the statute. While the letter dated 12/7/2025 was produced before this court at 1 o'clock by Mr. A.B. De Learned, standing counsel for the respondent number 1, 2, and 3. A copy of the letter was furnished Mr. S. De Learned, counsel for the petitioner, to obtain necessary instruction. And accordingly, Mr. De Learned, counsel for the petitioner, has obtained instruction and apprised this court at 3 p.m. today that the petitioner is agreeable to the letter dated 12/7/2025 and the decision of the Senate in its meeting held on 11/7/2025 on its 187th meeting. However, Mr. Day submits that the petitioner, the respondent authorities have stopped his fellowship when
February 2018.
February 2018.
No, Lord.
However, Mr. A.B. De Learned, counsel for the respondent number 1, 2, and 3, has controverted the same. Under the given facts and circumstances, this court is inclined to close this petition by directing the petitioner herein to file an file an appeal to the respondent number 1, 2, and 3 in respect of releasing his pending scholarship, the pending fellowship, and on receipt of the and on such appeal being filed, the respondent number 1, 2, and 3 shall consider the same in accordance with law.
After joining, my lord, after joining the institute.
Pardon?
After joining the institute.
After joining in the institute. Joining in the institute. In terms of this petition is closed. The letter and minutes of meeting of the Senate orders before the court to the salvage part of the
Most obliged.
Item 30.
Wait, this is your lordship. Lordship, this appeal, lordship, in this case, lordship, the insurance company proved that the driver did not have a valid driving license to drive a HMB, and also that there was no endorsement. The learned member, lordship, at paragraph 9 and 10 discussed the law relating to that, like pay and recovery and everything, but in the end directed the insurance company to pay the amount. There was no order for pay and recovery. At that apart, lordship, this case is of 2024, lordship. As per the new act, lordship, now pay and recovery is no more there. Earlier act, it was there, that proviso was there. It was removed
No, may
from.
not be, but the decision of the Supreme Court is there.
No, that Devangan, no, lordship, that is for LMV. That judgment is LMV vehicle license. He can drive a commercial vehicle or goods vehicle. Fine, no dispute. Here we have a HMV, lordship, and the gross weight is 42,000, lordship. And LMV definition is, lordship, 7,500. So, and then this was a tanker, lordship. The hazardous endorsement is required in a.
Anyway,
Yes, lord.
we'll hear you.
Yes, lordship.
Third, Ms. R.D. Mazumdar, learned counsel for the appellate. This appeal under section 173 of the MD Act 1988 is directed against the judgment in award dated 25th of March 2025, passed by the learned member, motor accident plate terminal number 3, Kamrup and Guwahati, in MSC case number 2037 of 2018.
Lordship. No, Lordship. In this case, my argument is different. Sorry, Lordship, I was arguing about 23. In this case, Lordship, the Assam government, Purnima coach, Lordship.
Yes.
Yes, in this case, Lordship, she is getting the pensionary benefit as per Assam government notification. So our challenge is the compensation, Lordship.
Okay.
I'm very sorry, Lordship.
Where is the memo of appeal? No, it is to be noted here that by the impugn judgment in award dated so and so, the learned tribunal has directed the appellant herein. The Oriental New India Assurance Company Limited to pay a sum of rupees
64 lakh.
64,83,170 rupees being the compensation to the respondents here.
9% interest.
Where is and also directed to pay. Also directed to pay interest at a rate of 9% per annum. From the date of. Who is that?
Date of filing the 4/10/2018. At
From the
least
date of filing of the claim petition. That is 4/10/2018 till realization. Where is the memo of appeal and the grounds mentioned therein? And also where is the impugn judgment and award dated so and so. Admit issue notice to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process. Within a week from today. List of the dismissal call for the record from the learned tribunal. List of the 4 weeks. I let the other party appear.
Yes, Lordship.
I issue notice.
Hello, blessed.
31.
Back to Lordship, my lord. My lord, I am appearing on my twin brother, my lord, on behalf of my twin brother, S. Roman, my lord, who has suffered a heart attack, my lord, and he has undergone bypass surgery, my lord, at Ayurveda Hospital, my lord. So, my lord, I pray before Lordship, my lord, this item may be fixed, my lord, in the month of August last part, my lord. In the meantime, my lord, I can take steps, my lord, on the other side.
Pardon is that?
I'm my lord, S.S.A. Rahman.
S.S.A. Rahman, learned counsel for the Appellate. In this appeal under section 173 of the MB Act is directed against the judgment and award dated 25/3/2025 hospital learned member MSC number 1 Guwahati, Kamrup Guwahati, MSC case number 2156 of 2015. Is to be noted here that by the impugn judgment and award dated so and so, the learned tribunal has directed the respondent New India Assurance Company Limited to pay a sum of rupees 11 lakhs 91,302 rupees, being the compensation to the appellant. To the appellant. You know, what is the amount, total amount?
My lord, because actually, my lord, this case is handled by my brother, my lord. Actually, I'm not
You are not aware of.
I'm not aware of it, my lord.
Okay.
I honestly confess it.
That's how 36 lakhs 91,302 rupees. With interest at a rate of 6% per annum from 4 to 2022 till its realization. There is the memo of appeal and the grounds mentioned therein, and also there is the impugn judgment and award dated 25/3/2025. Admit issue notice to the respondents, returnable in 4 weeks, that be taken by the cert post with AD and also by usual process within a week from today. Recess shall call for the record from the learned tribunal. list the matter after 4 weeks.
Arise, my lord. 32.
This case already I had mentioned, Lordship, by mistake at that time, is regarding the driving license.
Ordinance, Artie Mozumdar, learned counsel for the appellant. This appeal under section 173 of the IMD Act is directed against the judgment and award dated 12/3/2025 passed by the learned member, Motor Accident Claim Tribunal, Srirang Kazalgaon, in MSC case number 13 of 2024. It's to be noted here that by the judgment and award dated so the learned tribunal has directed the appellant hearing to pay sum of rupees 13,65,000. Paying the compensation to the respondents hearing with interest at the rate of 6% per annum from the date of filing of the claim petition. First, the memo of appeal and the grounds mentioned therein, and also first the impugned judgment and award dated 12/3/2025. Admit issue notice to the respondents returnable in 4 weeks that be taken by registered court with AD and also the usual process within a week from today. Basis will call for the report from the learned tribunal. List the matter after 4 weeks. Here is IA.
I is there, Lordship, 2133. We will need a stay, Lordship, because we are not liable as per the new act. And or else, Lordship, let them appear. I'll press it that time.
Okay, let them appear.
Yes, Lordship. Highly
Will
obliged.
issue notice? Issue notice.
Notice in the I also, Lordship.
IA also.
Fine, like
33.
May it please your lordship. Lordship, can this matter be taken up Friday or Monday next? Lordship?
Why?
Because I could not look at the connected papers.
Okay.
Either this Friday or Monday, Lordship.
Mr. R. Goswami, learned counsel for the appellant. Price for listing the matter on next Monday. They are allowed.
Even.
Problem. 34.
Lordship, in this case, Lordship, monthly income of the victim was taken as 15,000 at a higher side, Lordship. And postmortem examination was also not conducted over the dead body, Lordship. And only wife is the sole claimant. So 1/3 should have been deducted for living and personal expenses. Sorry.
No, is
50%
there
should
any
have-
statutory requirement for conducting this postmortem examination in cases under the MSCP?
Lordship, where there is doubt
MBA?
regarding. Lordship, where there is doubt about the cause of death, in that case, there is, Lordship, requirement of conducting postmortem.
No, whether any police case has been registered.
Yes, Lordship, police case is registered.
Then
So, Lordship, in accidental death cases, Lordship, postmortem was generally conducted to ascertain the cause of death, Lordship. In this case, Lordship, doctor was also not examined to ascertain the cause. And regarding quantum, Lordship, his monthly income is taken as 15,000. That is in the higher side, Lordship.
Art Mr. A.J. Soikia, learned counsel for the appellant. This appeal under section 173 of the IMP Act is directed against the judgment and award dated 19th of March 2025 passed by the learned member, Motor Accident Claim Tribunal, number 2, Hailakandi. It is to be noted here that by the impugned judgment and award dated so, the learned tribunal has directed to pay the appellant hearing is sum of rupees 27,88,000 being the compensation to the respondents hearing with interest at the rate of 6% per annum from the date of filing of the claim petition till the date of payment. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn judgment and award dated 29th of March 2025. Admit, issue notice to the respondents, the attorney will enforce that be taken by registered both with AD and also by the process with. Raise is all for the record from the learned tribunal. Please another after 4 weeks.
I lordship, we are ready to deposit 50%, not to be released lordship. Maybe state lordship.
50%. Okay.
For bail hearing, 25.
The prejudice. So this is the second time, my lord, on the limited ground, my lord, CD was called for as to whether ground of arrest has been mentioned in the notice under section 50. The record is there. I have also not flag marked it. My lord, my submission, there's the ground of arrest has not been mentioned therein. Ground of arrest. Apart from that, another ground, my
Have
lord,
you enforced that notice?
notice under section 50.
Yes.
Lordship.
Part of the record?
Yes, my lord.
Your petition?
No, my lord, the LCR was called for. The LCR has come. There we have.
Yes,
Yes,
Protocol, have you gone through it?
Yes, well, I have gone through the LCR. Yes, well, grounds of arrest is not there in say, notice under section 50 CRPC. And my lord, I have also flag marked one order of the trial court, my lord. And the trial court, my lord, your lordship may kindly peruse that order of the trial court trial at the time of my lord producing the accused before the trial court. And at no point of time, my case is pending since long in the trial court. At no point of time, these grounds were raised before the trial court.
No, the requirement of law is that it should be communicated to the accused at the time of causing arrest.
Yes, my lord, regarding that, my lord, in the second.
How this order will help you?
Let them, my lord, that otherwise trial court also have the power to, my lord, already because that from the earlier order of the trial court, it reflects that at the time of arrest, my lord, all those, my lord, procedure where, my lord.
There is no mention in that order that the ground of arrest was communicated by the IO.
Regarding section 50, yes, my lord, that is not there.
Then
That is
if
not
it is not there, we will assume that it is there. Is it your submission?
No, let them first raise all these grounds before the trial court, my lord, because they have never raised all these grounds before the trial court. If they would have raised all these grounds before the trial court.
No, they have already approached this court by filing this.
Because earlier your lordship has rejected on this bail application on 7/2/25. At that point of time also, my lord, these grounds were not raised before the trial.
Maybe
Before your lordship.
at that point of time, perhaps there was no decision of the Supreme Court.
Yes, from Bian
It was there, my lord, it was already there, but then, my lord, this somehow, my lord, escaped there for second time. Lordship has specifically admitted this application and called for the LCR to see whether this ground of arrest is not there, because it has been interpreted that violation of the fundamental right under Article 220, 22(1) of the Constitution of India in the this Purkastha case as well as the Bahan case, Bahan Kumar case.
Okay. Heard, Mr. Is.S. Soikia, learned counsel, senior counsel assisted by Mr.
P. Bordoloi, lordship.
P. Bordoloi, learned counsel for the accused, and Mr. P. Barthakur, learned additional PP for the state respondent. Its application under section 483 of the BNSS 2023 is preferred by two accused, namely Sri Santosh Setri and Srimati Rekha Setri, who are languishing in jail since 6/5/2024 in connection with NDPS case number 38 of 2024, arising out of Lekhapani PS case number 21 of 2024, under section 21C/29 of the NDPS Act, for grant of bail. Mr. Soikia, learned counsel for the petitioner, for the accused, submits that this is the third application.
Before this court, second
Second application.
Second.
This is the second bail application before this court. And the first one was rejected by order dated
5/3/25.
24.
Oh, my lord,
7/2/2024. Mr. Soikia further submits that this petition is preferred. The second bail petition is preferred on the ground that at the time of causing arrest of the accused persons, the IO has not communicated to the accused persons the ground of arrest. And in that view of the matter, the right granted under Article 22(1) of the Constitution of India and also the law laid down by Honorable Supreme Court in the case of Bihan Kumar.
as well as
What is the citation?
2025 SCC online SC
2025 SCC
269
online. Page number?
269
Page number?
269
269. And also the
Pobipur custom
decision of Honorable Supreme Court in the case of Pobipur Casto
2024 8 SCC 254
254 has been violated, and on such count the accused are entitled to bail. So P. Borthakur, learned additional PP, clearly submits that he has carefully gone through the scanned copy of the record received from the learned trial court, and he found that in the notice issued to the accused person under section 50 of the CRPC, no ground for arrest was communicated to the accused persons. But referring to an order of the learned trial court dated 6/5/2024, Mr. Borthakur submits that there the learned trial court has made an observation the ground of arrest have been satisfied and all the formalities of arrest have been complied with, and as such arrest is justified. But having gone through the notice issued to the accused persons under section 50 and also the memo of arrest and the inspection memo of the accused persons, this court is unable to derive satisfaction that the ground of arrest were communicated to the accused person at the time of causing arrest by the IO. And in that view of the matter, both the accused persons are entitled to bail. Accordingly, it is provided that on furnishing a bond of rupees 50,000 each with one security of like amount to the satisfaction of the learned trial court, both the accused shall be enlarged on bail. It is further provided that the learned trial court will be at liberty to impose any other condition so as to ensure attendance of the accused persons during the course of trial. In terms of bail application, bail petitions, stands disposal.
Acknowledged.
Item number 41, rule to CPC. Number 36.
Thank you, your lordship. My lord, this appeal is yet to be admitted, my lord. And my learned friend was second time earlier date. My lord, in this case, my lord, I have submitted the additional affidavit, my lord. Your lordship was directed to file regarding, my lord, some additional documents. I have submitted regarding my lord, our plea is this appellant are poor person, my lord. They are living below poverty line, my lord. And at that point of time, one person who was leading the case, he was outside, my lord, in Kerala, my lord. That's why some delay because in preferring, my lord, title appeal, my lord. But learned court, a trial court, my appellate court was pleased to dismiss that petition, and consequently, my lord, appeal was also dismissed, my lord. And that's my second appeal.
So the appeal has already been admitted. But at the time of admission, no substantial question of law were
Yes, sir.
framed.
Yes.
So therefore, the matter is listed for hearing.
Yes, ma'am. So, my lord, let the appeal, my lord. On merit, my lord, it may be heard, my lord, because that was dismissed on
There
the.
is a concurrent finding of both the courts below.
No, my lord, they have filed title appeal, my lord, and in the filing of the title appeal, my lord, there was a delay of 1 year, 7 months, my lord. They have submitted petition, my lord, for condonation of delay, and that petition was dismissed, my lord, and consequently, my lord,
No,
it
no,
was also
the-
dismissed. So this is.
So this is against the rejection of the application under section 5.
Five, my lord.
Okay. Yes, have you received a copy of
My
the
lord, my
affidavit?
lord, I received my. My lord, my only submission is that, my lord, there is a delay of 591 days, my lord. 1 year, 7 months, 14 days, my lord.
Hmm.
And the law is that, my lord, each day's delay has to be explained, my lord. Now, I have seen, my lord, I have gone through the order passed by the Garnet court below, my lord. I don't see any apparent illegality in the order. If your lordship will kindly see page number 60, my lord, that is the delay condonation petition, my lord, section 5. Well, they say that, my lord, they had deputed only one of the respondents, the defendant number 4, to take steps for filing of an appeal. My lord, now they say that, my lord, that particular defendant, he went to Kerala or he went to Andhra Pradesh, my lord, and
Yes, sir.
because of that, my lord, he did not take steps. Now, if your lordship will kindly see from para 4 onwards, my lord, there is no specific date on which date he went, my lord. Whether he actually went or not, no such particular proof was also, my lord, submitted at that point of time, my lord, that this person actually went to Kerala for work or when he returned. Because, my lord, in our written objection, my lord, we had taken a specific plea that, my lord, the appeal was filed on 12/9/2023. And on, my lord, 31/5/2023, my lord, the same defendants, my lord, they filed a separate suit. That means, my lord, this person was present in Assam, my lord, on 31/5/2023. That, my lord, we have always also annexed
You
that.
have filed objection here.
Yes, my lord, before the court below, the
No,
objection.
no, in this application or no, in this second appeal, you have filed objection.
No. That is only in the record, my lord. If your lordship will kindly see our objection, my lord, at page number 67. This is the title suit, my lord, filed by these present defendants, my lord, on 31/5/2023. 31/5/2023. These very defendants filed a separate suit. Meaning thereby, my lord, these particular defendants were present, and assuming that, my lord, they were present on 31/5/2023, since 31/5/2023 till, my lord, 12/9/2023, that part of delay has not been explained.
My lord, everyday delay is
31/5/2023 till
12/9/2023.
when the interim judgment was
Judgment is
passed,
29/1/2022.
29/1/2022.
According to them, my lord, from 29/1/2022 till the date of filing of this appeal, this particular defendant number 4 was outside Assam. But we submitted this copy of this plain from where it is evident that this person was present on 12/9/2023, on 31/5/2023. That means, my lord, first of all, my lord, their submission is, my lord, erroneous because we have submitted documentary evidence, and even assuming that the person was present, then what happened?
Yes, Mr. Uddin, from your own document, it appears that on 31/5/2023, you were here in Assam.
My lord, that was filed, my lord, because here, my lord, defendant, that means appellant was, my lord, not only one, my lord. My lord, there, my lord, 4 appellant, my lord.
And that's already.
But we have taken that one of the.
Appellant herein is the plaintiff in the title suit number 71 of 2023,
Yes, my lord.
right?
And this person had put his thumb impression, a signature also, my lord. If your lordship will see page number 67, this person's signature is there on the plain. So he was present on that day.
My lord, we have taken another ground because of the poverty, my lord. Because
No,
there,
forget about your poverty. Your own document belies your case. This is your document.
yes, one
Annexure
case.
8.
This was separate case, my
This
lord.
was filed on 31/5/2023. On that day, you have put your signature there.
Yes, my lord. That was there, my lord. The case was filed, my lord.
Then how do you justify that at the relevant point of time you were in Chennai? Why we should not dismiss this appeal, imposing a heavy cost upon you
My lord,
for misleading the court?
my lord, that I have also, my lord, annexed in my that, my lord, the particular appeal, my lord. It was filed on, my lord, 12/9/2023, my lord. Annexure 1, my lord, page 51, my lord. This date is there, my lord. And my lord, date, certificate, and this appeal was, my lord, certified by, my lord, advocate, my lord, on 12/9/2023.
Where is your petition under section 5?
My lord, that petition, you will find
Page number 59.
page number 59.
Not Chennai, it is Kerala in Andhra Pradesh.
Yes, ma'am.
Yes.
So you see the judgment and decree was passed on 29/1/2022. Thereafter, when you have obtained the certified copy and when you were there at Kerala and Andhra Pradesh and when you have returned, where is the explanation?
That explanation, day-to-day explanation is not there, madam.
Not day to day. Not day to day. Okay, Mr. Das, today let us frame one substantial question of law today. Then fix the matter for here. We'll finally make a call. Heard Mr. Jiutin, learned counsel for the appellate. Then also heard Mr. S. Das, learned counsel for the respondent. This second appeal under section 100 of the CPC has already been admitted. No, not admitted. In this second appeal under section 100 of the CPC, notice has already been issued to the respondent by order dated 11/12/2024. And the records have also been called for from the learned courts below. Courts below. And accordingly, Mr. S. Das, learned counsel for the respondent, entered appearance. And it appears that at the time of issuing notice, no substantial question of law has been framed. And accordingly, the matter is listed today for framing of substantial question of law. It is to be noted here that the second appeal under section 100 of the CPC is directed against the judgment and decree dated 23rd/4/2024 passed by the learned civil judge senior division Barpeta entitled appeal number 28 of 2023. This to be noted here that by impugned judgment and decree dated so and so, the learned civil judge senior division Barpeta has rejected the application filed under section 5 of the Limitation Act by the appellant herein and thereby dismiss the title appeal. This second appeal under section 100 of the CPC is admitted on the following substantial question of law.
My lord, third, I may not rely upon, my lord. Third question of law, my lord, is not really that matter. Third one. Due to time, some typographical error, my lord. 1, 2, 4, 5.
Whether the learned First Appellate Court, whether the judgment, impugn judgment and decree dated 23rd/4/2024 passed by the learned Civil Judge Senior Division Barpeta suffers from perversity or non-consideration of the grounds of failing to file the appeal within the stipulated period by the appellant hearing. Since the parties have already entered appearance and the LCR has also been received. Recessal list the matter on. This month, on 22nd of this month, for hearing and final disposal of the appeal. 24th.
Right.
37.
This Lordship. So as per last office note that the Lordship service has been completed to Lordship. LCR has been also received to Lordship. Since the matter has been already admitted and fixed for hearing, Your Lordship.
Service not completed.
Complete, Your Lordship.
Completed.
Yes. LCR also received, Lordship.
Heard, Mr.
T. Gogoi, Your Lordship. T. Gogoi.
Learned Counsel for the appellate.
Yes, Lordship.
Office note dated 3/6/2025 indicates that service upon the respondents already completed. And LCR has also been received. In view of above, it is provided that this is a list of matter for hearing.
Your Lordship.
LCR is received or not received?
Received, Lordship.
LCR. Record decision. List of matter on. Oh, okay. This is a list of matter for hearing in usual course. List of recent matter.
38.
My lord, my case was dismissed for default, my lord. My lord, there is a petition for condonation of delay of 51 days. My lord, I refer to letter of order dated 18/12/2024. My learned friend taken time to file objection, but objection till date is not filed. Order dated 18/12/2024.
My lord, earlier it was dismissed for 2 occasions. On the last date also, my friend is referring on 18/12, they were absent. My lord, thereafter, the son of the respondent, sole respondent has died. He's in his native place at Bihar. So we need 4 weeks time to file our objection to this condonation application. Only earlier also there were 2 dismissals. Then it was restored. So similar conduct is going on. So we will be filing a objection to this application.
Heard Mr. MSA, learned counsel for the petitioner. No, learned counsel for the applicant, and also heard Mr.
G. Khandelia, Lordship.
G. Candelia, learned counsel for the respondent. Mr. Candelia submits that the son of the respondent suffered demise.
He has died.
When?
yesterday I called him after getting the list. He said that he's in under bereavement and he needs some
he
time.
left for Bihar. And he pressed for listing the matter after 4 weeks, so as to enable him to file objection. Here is accordingly allowed, rest is list the matter after 4 weeks.
Much obliged.
39.
Your Lordship. Appellant before your Lordship is Assam Power Distribution Company Limited, Lordship. There is a delay of 103 days in preferring the miscellaneous first appeal, Lordship, challenging the judgment and award passed by the learned employees compensation commissioner, Lordship. Gulagrad. Service in respect of respondent number 1 and 2 has already been completed, but none has entered appearance representing them, Lordship. We have taken dusty service for them also. Because of official correspondences, there was delay and
Heard Mr. Arbora, learned counsel for the applicant. None appears for the respondent on call. To office note. Though notice upon the respondent number 1 and 2 were served by Dusty Mode. And affidavit to that effect was also filed. Mr. Bora, learned counsel for the applicant submits that this application under section 5 of the Limitation Act is preferred for condonation of delay of 103 days in filing first appeal, challenging the judgment and award dated 28/9/2023 passed by the learned commissioner. Employees compensation Gulagat in employees compensation case number 14 of 2014. Whereby the learned whereby the applicant herein was directed to pay compensation of rupees 8,36,920 rupees with interest at the rate of 12% per annum upon the principal amount from the date of filing of the claim petition till the date of realization. And also granted liberty to the applicant to recover the awarded amount from the opposite party number 2. Mr. Bora, learned counsel for the applicant submits that. Though the judgment and award was passed on 20/9/2023, the appeal could not be deferred in time. And the ground has been explained in paragraph number
3, Lordship. Page number 4 and
paragraph
5.
number 3 of the application. And that the delay is not intentional and rather it is circumstantial, and under such circumstances, Mr. Bora has contented to allow this application. Having heard the submission of Mr. Bora, learned counsel for the applicant, I have carefully gone through the petition, the documents, present record, and also perused the statement and environment made in the paragraph number 3 of the application. And it appears that though the award was passed on 28/9/2023, the same was supposed to be filed on 28/11/2023. And after obtaining the certified copy of the impugned judgment and order, the same was sent to the Deputy General Manager Law APDCL for necessary action. And thereafter, the Assistant General Manager Law APDCL on 38/11/2023 sent the aforementioned copy of judgment along with a letter to the Standing Council of APDCL with a request to file an appeal. And thereafter, the learned council, Standing Council, has furnished his opinion on 14/12/2023 to file the appeal. And in the meantime, (103 days) elapsed. Taking note of the submission of Mr. Bora, learned counsel for the applicant, and also considering the explanations of forthcoming, this court is of the view that the delay of 103 days in preparing appeal has sufficiently been explained, and accordingly the same is since condemned. In view of the order passed in by number so and so, now the registry will proceed to register the appeal and list the matter. Now list the same before the court as soon as practical.
Item 40.
Please, Your Honor. By representing the older respondent here.
Okay. Record was not called for at the time of admission.
Your Lordship,
Record was not called for at the time of admission.
This is the second time when the matter is called for, Your Honor.
Pardon?
Your Honor, this is the second time the matter is called for, Your Honor. First the motion was there and then service was done, and but there.
No, the matter has already
Yes,
been
yeah.
admitted.
Yes, Your Lord.
Heard, miss? Your name?
Manjushree Padgiri.
Manjushree?
Padgiri.
Learned counsel for the applicant. Learned counsel for the appellant. And miss?
Lonnie does, L does.
L does, learned counsel for all the respondents. It appears from the order dated 7/2/2025 that the appeal has already been admitted. But it appears that the record has not yet been called for from the learned courts below. Accordingly, it is provided that registrar shall call for the record from the learned court below and list the matter after 4 weeks for hearing. 4 weeks.
41.
My pleasure, Lordship. Respondent has appeared, Miller. So to date, if Lordship permits.
Yes, you have filed any objection here?
So we just need some further time to file the objection. Actually, the concerned branch officer has been transferred. There's been a slew of transfer in the bank. If we get a short date, Your Honor, my lord will be able to file the objection.
Well, it's a revision against the so objection.
But even if it goes for hearing, I mean, we wanted to file an objection, but even if it goes for hearing, we are ready for hearing within a very short date, my lord.
Short date. Heard Mr. Sahu, learned counsel for the petitioner, and Mr.
J. Borua.
J. Borua, learned counsel for the respondent. Yes, agreed by learned advocates of both the parties, raises and lays the matter on public, etc.
My lord, in the trial court, the case has been fixed on 30 of July, prior to date, my lord, otherwise.
It hasn't fixed for cross-examination of the plaintiff. my lord.
Yes, that is why,
So it is their prerogative. They can file a petition and seek an adjournment that day.
but they are, because stay was not granted, my lord, that was.
Cross-examination of plaintiff, my lord, won't affect the outcome of any title suit. It's just the beginning of the suit, your my lord.
And he's the plaintiff there.
We are the plaintiff.
Oh,
in
you
the-
are the
we are the plaintiff in the parent suit.
Yeah, let it be in the month of August, because already we have takes a large number of cases in the month of July.
Problem is that on the 30th of July. the
No, you
case-
file an application there.
42
That be fixed, my lord.
on 12th August.
12th,
42.
March.
for admission, my lord.
Oh, admission here.
I believe the lords. I think the IA 576. Suppose stay of the person of the judgment and liquidation 511 lots. 570. Also, what had happened, the opposite party had entered an agreement with DPS, Delhi Public School Numaligarh, who is former opposite party here. We were not privy to the contract which they have entered with DPS Numaligarh also. I am appearing for Numaligarh Refinery Limited also. As the opposite party had entered into a contract for providing some services. That contract was terminated by a letter dated in 2011, it was terminated. 19/11/2010, it was terminated. After the termination of it, they filed a suit seeking declaration that the letter dated 19/11/2010, by which the contract was terminated, may be declared as illegal and void. In that suit, the suit was decreed, and it was declared that the letter dated termination letter is bad, and it was set aside. Then what had happened, Lordship? They had not paid
So
for
you see, the matter is listed in the order column today.
Yes.
This I is for what purpose?
I suppose stay, Lord.
Stay.
Stay.
Yes.
I am for the respondent number 1, Lordship here.
Yeah.
We are the decreed plaintiff here, on the title suit 2 of here the appellant, they have prayed for the stay of the execution of the judgment decree dated 5/11/2024. But on the petition there is no execution. We have till now not any executed or any information of doing an execution, title execution on behalf of the on the decree, your lordship.
No execution case was filed.
Yes, your honor. Yes, lordship, because we have not received any information from the plaintiff or from our, as of now, we have not received any communication or any information that an execution has been proceeded till. We would like to file an affidavit in reply, lordship, from the on behalf of the respondent number 1.
I don't know, because execution file for na.
For the information.
Oh, information that I cannot.
So whether the appeal is ready for hearing?
Yes, LC has been.
If lordship
LC
an execution has been proceeded, then there should be a copy of the execution in the plain itself. But there is no execution copy annexed here in the IA.
No, you are for the decree holder.
Yes, I am for the decree holder responding
Are
number.
you not sure that you have not filed any application there for
Yes,
execution?
lordship. We have
Not filed.
communicated with our client, and they have said that he has not executed any title execution or any proceeding. We will like to take an.
So we'll finally hear and dispose of the appeal.
Yes. Fix it.
Mr. Gogoi, learned counsel for the applicant, and Mr.
G dash lordship.
G does, learned counsel for the respondent. After hearing, learned counsel for the, you pass the order in I. After hearing, learned counsel for both the parties, it is provided that residents shall list this interlocutory application along with the RFA number 9 of 2025 for final hearing. In the on 7th of August. Whether record was called for?
Yes, record was called for and it has come.
Record received.
That is a record.
Record received. Okay.
Mid-page, Your Lordship. This IA has been filed for seeking an early hearing of the regular second appeal, Lordship. 853. And as per office note dated 10/7/2025, Lordship, AD cards in respect of some of the respondent has not been yet received. And the usual process report also not yet received by the section, Lordship. May I point out one thing in this case, Lordship, in regular second appeal, we have taken several times issued notice in this regular second appeal. And thereafter, Lordship, Dusty service also we have taken and thereafter we filed Dusty affidavit. They refused to accept notice, Lordship. So may I pray before your Lordship to direct the concerned Munsif court to ascertain whether usual service can be served upon the respondents or not, as because from the 10/7/2025 order, it reflects that moreover, no service report has been received in regard to notices issued by usual process on 8/4/25 till date. So the concerned Munsif court will be Hujai, Lordship.
Heard Ms. Harsodune, learned counsel for the applicant. Office note dated 10/7/2025 indicates that no service report has been received. In regards to the notice issued by usual process on 8/4/2025 till date. Ms. Chaudhary submits that the resume may be directed to obtain a report from the Court of Learned Munsif number, Munsif
Hujai.
Munsif Hujai.
Yes,
regarding effecting service of notice upon the respondent by usual process. Fair is accordingly allowed. Fair is accordingly allowed. Resident shall obtain a report from the Munsif Hujai regarding service of notice upon the respondent.
Lordship.
Number
Normally, Lordship.
3 for all the respondents.
All the respondents, Lordship.
All the respondents from respondent number 1 to respondent number. Last one is 12.
Yes, Lordship.
Respondent number 12. 12 or 7?
9, Lordship. Kamala Bibi. No, Lordship. That is 7, Lordship. Page 9, 7. There are so many respondents, but they are numbered as 6.1, 6.2.
Okay. This after 3 weeks.
Lordship. In this case, normally, Lordship, in early hearing petition, no notice is required to be served. But in this case, they did not appear in the main regular second appeal. So your Lordship has issued notice in IA also.
44.
Obliged, Lordship. In regular second appeal, there is an order, Lordship, already service complete, LCR received, matter may be listed for hearing. As per order dated, Lordship, 21/2/2025.
And let the report come, we will see.
Lordship, for that only, as already notice was issued, so we can wait for some more time, and thereafter, if they do not, Lordship turn over, then your Lordship may fix for hearing. Obliged, Lordship.
May I plead the lordship? Lordship, this matter, IA has been filed. Lordship, what has happened in the order? Paragraph number 13, your lordship. All the intention of the paragraph comes out, but since the date is missing, they have interpreted, if I may read it, your lordship, paragraph 13, this of the judgment, page 15 of the IA.
That's all right. Where is the mistake?
No mistake, your lordship, just date has been reflected there, but at the end part, if the date is the last line, in the given facts and circumstances, this court is of the view that on equitable consideration, the petitioner is entitled to interest, here in this case, upon her deferred portion of salary from the due dates. Just before that, your lordship has written, she was compelled to approach this court by filing the present petition, and during pendency of the petition, the amount was paid to her by sanction letter dated 12/3/2025 after more than 6 years. So, lordship, this from the due dates, so ultimate realization was done on 12/3/2025. So that date needs to be there so that the interest can be calculated.
Who is that?
The date when actually they have released the amount, 12/3/2025.
20?
12/3/2025.
Okay.
From the due date till 12/3/2025, that if that is added, the whole things gets, that is the only thing. In the above paragraph, it is mentioned, she was compelled to approach this court by filing the present petition, and during pendency of the petition, the amount was paid to her by sanction letter dated 12/3/2025 after more than 6 years. In the given facts and circumstances, this court has the view that on equitable consideration, the petitioner is entitled to interest, here in this case, upon a deferred portion of salary from the due dates. Then, if it is specified, due dates till 12/3/2025, then the calculation of interest will be possible.
So due date will be 12/3/2025.
Yes, because on that day they have sanctioned us, while the case was pending, they have given us the money. So till then the interest will be calculated. That is the from the due dates till 12/3/2025.
Due dates,
Due dates in the next page, para 14, lordship will reflect it. The petitioner shall be paid interest at the rate of 6% per annum for a deferred portion of salary. That period is noted, but the calculation of interest has to be on the date of realization, till the date of realization. That was missed. Period is mentioned.
so till the date of payment,
Yes, till the date of realization.
that has to be incorporated here.
Yes, yes. That is 12/3/2025.
Yes, madam, any objection? Heard Mr. K.K. Mohanto, K.M. Mohanto, learned counsel for the petitioner, no, for the applicant, and also heard Ms. Teranti, learned counsel for the learned standing counsel for the respondent authorities. 1, 2,
Not one, lordship, 3 and 5.
3 and 5. 3 and 5. This interlocutory application is referred by the applicant for clarification of the final judgment and order dated 17/6/2025 passed by this court in WPC number 5796 of 2023. Mr. Mohanto, learned counsel for the applicant, submits that by order dated 17/6/2025, this court was pleased to dispose of the writ petition number 5796 of 2023.
Yes, sir.
With a direction. With following direction. Number 1, the petitioner shall be paid interest at the rate of 6% per annum from the deferred portion of the deferred portion of her salary with effect from 9/8/2018 till 31/12/2018. Number 2, the petitioner shall be paid for the unutilized leave of 15 days illegally deducted from the total period of 250 days of earned leave. But Mr. Monto pointed out that while passing the aforementioned direction of in respect of payment of interest at a rate of 6% per annum upon the deferred portion of salary with effect from 9/8 2008 till 31/12/2008 2018 this court has not fixed the date till when the interest will be counted. And Mr. Monto also pointed out that the amount has been sanctioned by the letter dated 12/3/2025, and as such, the interest shall be counted till 12/3/2025. Ms. Perampi, learned standing counsel for the respondent number so submits that she has no objection in clarifying the aforementioned aspect of the matter. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances, it is provided that the interest at the rate of 6% per annum for the deferred portion of salary of the petitioner with effect from 9/8/2018 till 31/12/2018 shall be paid till 12/3/2025, on which that the respondent authorities have sanctioned the amount. In terms of above, this IA stands closed.
If I appear for respondent number one also.
Respondent number one.
also.
Also, the other direction, the fourth direction is to be completed in a period of 4 months, that will remain the same. The direction which was given, the aforementioned exercise.
This
Para 15.
order.
Para 15.
Para?
Para 15, your lordship, that will remain the same. Para 15, page 16. Para 15, page 16.
That will be same.
That may be reflected because again the limitation.
The other direction in the order dated 17/6/2025 will remain same.
Deeply aware.
45.
Back to you, Lordship. Delay petition, my lord, there is a delay of 185 days in preparing this CRP. First time listed, my lord.
Heard Mr. Sahu, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 170 days in preparing connected.
Table revision petition.
Where you have mentioned it.
In the appear portion, my lord. At page 6.
In preparing connected civil revision petition. Let notice be issued to the respondent, returnable in 4 weeks. The be taken by registered post with AD and also by usual process within a list after 4 weeks.
53.
Objection.
Your Lordship, on the last date, we were directed to take steps upon the newly impleted legal heirs of respondent number 2 and file a fresh amended cause title. Your Lordship, the steps have been taken and as per the office note dated 9th July 2025, notice has been issued. However, it's too early for any AD card or unserved notice to be received.
Okay.
So we shall,
Wait for some time.
yes, Your Lordship. And also, Your Lordship, the amended cause title we have filed on 9th or 10th, like the second week of June, but it's not there in the records. The registry may be directed to.
You go and inquire from the registry.
Okay, yes, Your Lordship.
Heard Ms. Bayani, learned counsel for the applicant. Office note dated 9/7/2025 indicates that neither AD card nor answer notice has been received. List the matter after 2 weeks awaiting service report upon the respondents from opposite party.
Much obligation.
54.
May I please?
Lord, we have filed the affidavit in opposition against the petition for condonation of delay in IS civil number 160 of 2025.
When you have filed?
Lord,
Copy was supplied today. My lord. The copy. My lord,
Is it placed on record?
as in this morning, because the court was on holiday, I had serial number 31.
You have filed it on today.
Yes, because court was on holiday, so this morning.
Okay, let it be on
anyway, the
Wednesday.
delay is not inordinate, just 28 days, my lord. And I have occasioned the reason for
Maybe her objection is not available.
my lord,
before
my
this
lord,
court. Wednesday,
my lord.
heard Mr.
N Patiri.
N. Patiri.
N Patiri.
N. Patiri, learned counsel for the applicant, and also heard Ms. B. Soduri, learned counsel for the opposite party. Opposite party. Ms. Soduri submits that she has filed the objection today morning, and the same is not placed on record. Accordingly, it is provided that the shall list the matter on Wednesday. And closing the enclosing the objection filed by Ms. Soduri.